Okay, good morning, everyone. Welcome to the meeting of the Board of Land and Natural Resources. It's Friday, September the 13th. It's 9:04 a.m. We will defer the approval of the minutes. We will go directly to move up agenda item number 1, which is D10. Morning, Russell.
Morning, Land Board members. Russell Suji for the Land Division. Item D10 is our bringing back to the board for discussion and decision-making on our Naniloa lessee who is currently in bankruptcy. I know we don't have a submittal, but the title does indicate 3 questions that from what I understand, the trustee and the bank's lawyer had requested the board consider for this morning. I just thought I'd start out, and I know most of you have been generally briefed about the status of the bankruptcy. On one of the items, just because it may not be clear, on question number 1, when it talks about a construction bond, what it is in this particular lease, because we had a construction requirement paragraph of at least $5 million of improvements, we had a special provision that required a construction bond. At the end of the day, what was provided to us is what we had asked for, which is a labor and material means bond, protecting in case there's liens on the property, mechanic liens from contractors, laborers, etc., and completion bond, and that was provided. In this particular case, there are 3 towers: Kilauea, Mauna Kea, and Mauna Loa. Mauna Loa Tower is a tower that the operator, Ken Fujiyama, was not going to immediately start any construction. So he put that off, and we agreed that he did not have to bond that particular tower. I think the only thing he's done on that property, probably at the most, is cosmetic, such as changing carpet. On the Kilauea and Mauna Kea towers, there was construction, obviously. Mauna Kea was significantly improved, and pretty much there was a bond for the improvements of X amount of dollars that we had based on a cost breakdown that the Hawaii Outdoor Doors provided to us, and we had a bond, several $million for securing Mauna Kea Tower. He completed most of the improvements, and we did an inspection. We agreed ultimately to reduce the bond down to $211,000, and then we would release, with an agreement that would release the rest of the $211,000 from Mauna Kea after the notice of completion is filed, which is in the publication in the paper, giving notice to all material men, suppliers. If you have any liens or you didn't get paid, file your claim within 45 days. Otherwise, the mechanic lien law would bar you from getting a mechanic lien. It's not a lawsuit, but a mechanic lien, which is a super priority status in this particular. Anyway, to make a long story short, a lien action was filed, and we were provided notice of action arbitration award, so that bond is actually still in place from my understanding, and I think they're asking for the bond to be released. I think the trustee who is here today will attest, because we don't have the documents to prove it, that the lessee, Ken Fujiyama, paid the $211,000 or whatever was owed to the mechanic lienor, and that a stipulation to dismiss was filed. I don't have those documents. We don't have any in our records, but I think he'll attest to that. I don't have a problem releasing that if that is the case. The problem I have is Kilauea Tower. This one, we currently have a $1.1 million bond, roughly, and that is the tower that is gutted and is closed down because it is, it's a safety hazard. He gutted it, but he didn't really put in the improvements. So it's partially complete. Men did work, people did work. I don't know if there's claims out there, and there's been no notice of completion. Obviously, it's not completed, so there will be no notice of completion filed, telling everyone to file your claims. Anyway, from what I understand, I know it's worded whether the board will call it construction bond. I'm not sure if that's the correct term, but my understanding was in this $1.1 million bond, or both bonds that we're talking about today, there is a premium coming due. And I think the trustee wants to ask this board for relief of having to pay the premium, which would result in no bond. And in my opinion, the kilowatt tower could be subject to liens potentially in the future, lien actions. The other two questions, I think is self-explanatory. They're asking you to extend the time again for the the rent payment of $250,000, which was already due in August, which was supposed to be paid this month. They're asking it to be postponed to the end of the year. And the final item, if this board recalls, maybe a couple months ago, due to the bankruptcy proceeding and I guess the basic feeling of insecurity of the landlord, we had brought back to the board requesting that the performance bond of $1 million of the under the lease, which had been previously allowed by the board to be reduced to $500,000, go back to the full amount of $1 million, and the board approved that, despite testimony in opposition by Mr. Fujiyama. Since that time, no one has stepped forward to come up and replace the $500,000 to make it a full $1 million bond. And the bank and the trustee, I guess, is here to ask that the board further defer that. And that's your decision. When I brought that thing to the board, when I brought it to the board, I intended that the bond be immediately replaced to $1 million. I did not intend it to only be because Ken Fujiyama was operating the hotel. It's anyone operating a hotel, let's bring it back to $1 million in a bankruptcy proceeding. But that's why I brought it. How you voted is your kuleana. So I don't have, unless you have any questions, I think the trustee and the bank's lawyer is here. They want to probably present an argument for their what they're requesting of this board.
Any questions for staff?
Wait till after.
You wait till after
the
that.
bank trustee.
Does the trustee wish to come forward?
Good morning, gentlemen.
Good morning.
Chair and board members. My name is David Farmer. I am the Chapter 11 trustee for the Hawaii Outdoor Tours, Inc. Bankruptcy that is the lessee under the subject lease that we've been talking about. Basically, my job as a Chapter 11 trustee is twofold, other things, but in broad terms, twofold. One is to preserve the operations of the hotel, and secondly, to sell the hotel. And I will tell you that in baseball analogy, I'm batting 500 at this inning. We have preserved the operations. We are paying our taxes. We are paying our payroll. We have deferred items, and those are before you today. Let me just clarify. Mr. Suji raised this issue of the lien as far as the Mauna Kea hotel, Mauna Kea Tower. I'm sorry, and just so everyone is very clear, there was an arbitration. There was an award in an arbitration. The winning party moved to, as happens with arbitration awards, you go to court and get it enrolled as a judgment. That action was filed, and then it was dismissed. And it was dismissed because it was paid off. And so in terms, there is no lien. There never was a mechanics lien enrolled as a judgment. And so that, and I think Mr. Suji sort of alluded to the fact that that's kind of a non-issue. And that's the status of the Mauna Kea so-called lien. We have been trying with our best efforts to attract buyers to this property. And it has been a struggle, and it is at this juncture not a done deal. However, we do have interested parties who we are attempting to bring to the altar, as it were, and to make a actual transaction happen. We also have engaged a national, local, as well as a nationally visible brokerage firm, Colliers, to be our broker, to throw the net wider even than has been thrown thus far. We, and I say we, I think the creditors, the state, which is a creditor, the state of Hawaii is a creditor in this case, basically are asking for the time so that two things can happen. Number one, operations can continue so that we don't have, the last thing Hilo needs is another job disruption of people who've been working hard for many years at that hotel, who will be thrown out of a job if we close down operations. And we have a cash flow emergency that we just simply cannot address at this time. Now, it's not exactly, I'll pay you tomorrow for a hamburger today, because any buyer of this property will necessarily have to cure all amounts owing, including this number 2 item that we are asking for deferral to the end of the year. And once again, we are asking for that time frame because we believe that is a realistic time frame to secure, to get court approval, and get the sale done. Recognize this has been a case that's been out there since November of last year. I've been on duty since May 14th of this year. There are challenges with this property, there's no doubt about it, but the only way, in our view, of getting anything close to a good result is to preserve the operations, continue to preserve the operations, which also go into the value of the property, because once it's shut down, the value drops significantly, and allow us then, through that process, to be able to pay all the creditors that are in certainly line. The bank is a major creditor. The state is also a major creditor. We have unsecured creditors. Our hope is we can pay them as well. They may or may not be able to pay, depends upon what our amounts are. But that's the long and the short of it. That's why we are asking for this extension. And if there's any questions that I can address, I'll be happy to do that.
Questions for Dave?
So on the Kilauea Tower lien, what's the status of that? Is that as Mr. Suji represents?
Kilauea Tower has no lien. It never had a lien.
I mean the bond.
Well, the bond, again, we're asking for a deferral on the bond. The 500,000 bond remains in place. This, we're talking really about the raising it to the $1 million level. At this time, there's no construction going on. There's no notice of completion. The bond rights or rather the mechanics lien rights of any of the supply and material men and contractors are preserved. And once again, in the new ownership world, that will be an issue that will be dealt with. The new owner will have to deal with that. But at this juncture, our cash flow through the summer was good. April's always a good time for Merry Monarch time in Hilo. Tourism numbers were good this year, our cash flow through the summer, but we're in the dead zone now, relatively speaking, of tourism, especially at Hilo. And so this plus where we are with negotiations and hope for transactions of sale, that's the reason we need the time.
Are the interested buyers that you have in line now the same that you had before when the extension was given for the lease payment?
Which was, no, actually, these are, I'm only hesitating. One is definitely a more recent vintage, and I will say both are new since that time. I don't believe we had any letters of intent or anything that was, halfway serious at that time.
Can you tell the board? Can you tell the board anything about the nature of the buyers, the interested buyers, and what?
Well,
not necessarily who they are, but
yeah,
what their background is, and.
Well, these types of acquisitions are typically funded by hedge fund monies and developers who are in the process of acquiring through borrowed money. And essentially, I will say that both of these, I'm sorry, I've got a phone that's ringing, and I apologize. Let me make sure I turn it on. I would characterize both as being developers who are in the process. The reason that they're not up to the altar at this point is because they are securing the funds necessary. We've seen at least one demonstration proof of funds in one instance. One of these potential bidders has spent time at the hotel, not only looking at it, but also making measurements, costing out FF&E to rehabilitate, because besides getting the property moved on, I think the community, it's not necessarily a bankruptcy issue, but it's certainly the community's issue to not only get the property moving, but also to get it improved and bring it back to at least its 3-star status that it's historically been. And any investor in the property is going to want the same thing. So we've had at least one with boots on the ground, looking at the property, making measurements, costing out, talking to contractors, talking to the local building community in Hilo. So it's not just a twinkle in somebody's eye. We believe it's a real deal, and it's at a number and letter of intent that is a significant number that would certainly take out the prime creditors, that's my job, but also would transfer the property to somebody who's actually going to be able to do the right thing with that property, which is to rehabilitate it and to begin to make Banyan Drive the place it used to be.
I have a question.
Sure.
As you in the past, or you have said that you have some interested parties that want to be players. In your opinion, parties that you have now and say the parties that you had prior, right? What was the reason the ones prior didn't come to the plate, or what was the problems or issues that they had that the deal fell through?
I guess I would say, I don't believe we had priors. We've had the two that I'm talking about are the only ones that to me have been serious, letter of intent, really talking numbers that make sense in this bankruptcy. There really are no priors except these two, which are still alive. So we don't have a case of people sort of going that far and then backing off.
Okay.
We've had, frankly, inquiries with, in many cases, the usual suspects, if you will, but nothing solid in terms of, hey, we were actually close to a letter of intent, a number, or anything else. Only inquiries to either operate the hotel for the interim period, but nothing in terms of an offer that's anything close to an offer that they've walked away.
Nothing concrete.
Exactly.
Okay, now, the other side of the question, or the other side of this coin is, if the board is to grant you an extension, how soon or how long before the creditors would be paid? And the other, if the extension is, you have had extensions already.
Correct.
So how long would it take for your creditors, your major creditors, basically you here at the state, so will the state be paid?
The always sort of weasel words of a lawyer are, it depends. And
My mother uses that.
yeah, and moms and lawyers use this quite a lot. And the fact is that a bankruptcy is, like other litigation, is litigation. And in this instance, to maybe zone in more, direct your question more directly, it depends upon how quickly we can get a deal to go hard, to get it up before the bankruptcy court for approval, and at that point, there's a possibility of other players coming in and bidding up, like a foreclosure sale, for example. That's a possibility. I would say, for my sort of planning and goal purposes, that process is probably going to take the time necessary that we've asked for in the extension.
But you've had an extension before.
Understood, and when I was appointed, the hope was that within a short period of time, that any bashful brides at the back room would come forward and lay out their offers. That did not happen. It just did not happen. And hence the reason that we're asking, did ask and are asking for an extension. Now,
But you kind of answered your question. The bashful brides didn't come forward.
correct.
So that tells me, or at least for me only, that these players are not that interested.
Well,
The brides are not interested in coming to the altar.
I would say at the time of the first request for extension, we didn't even have people in the waiting room.
Okay?
That's the difference. That's really the difference.
Other questions for Dave?
Well, just one more follow-up. I know I don't want to beat this to the death. It was relayed the last time we did an extension. I was, unless I heard wrong, it was relayed that someone was actually doing their inspection. And that's kind of,
That's one of the,
okay. All right,
that's,
so
that
that's,
is
I mean,
one
that
of
was
the.
a level.
Yes,
And that was a big factor that, okay, we have a very interested party.
correct.
Let's give these guys a chance to try to think. So now this party that did their inspection, is this still one of your,
They still are in the game, and again, frankly,
did the
from,
inspection pass in there?
well, their
No,
inspection
there's a
was
time
what
frame.
I alluded to, which is actually kicking the tires, looking at the rooms, making measurements, trying to cost out what renovations would be, who the purveyors, local purveyors would be.
Mr. Farmer, that was my question to
Yeah.
you, and you answered that they were two new interests.
That's what-
Now
Right, and
saying
you're,
that-
and you're refreshing, and I apologize for the miscue on that, because that is true. That those players were, that particular entity was on, and still is, it still is a player. The other is a brand new one, so I apologize.
Further question?
Yeah, I got just a couple more things. One, so the previous delinquencies that were cured, they were cured by the bank and not the bankruptcy court, the bankruptcy court funds, is that correct?
We're talking about the lease rent payment in December, I believe, of last year, was paid by the bank, correct? I believe it was.
But then there was another, wasn't there another delinquency since bankruptcy that the?
Of the lease rent?
Yeah.
Don't-
Just the one?
Clarification, that was the short on the bond, called the
Was short on the bond?
That was the December payment.
Okay. And then I'm not sure that the board understands the relationship between the bankruptcy and your role as a trustee and then the bank's interest. So from your perspective, could you just briefly explain to the board that position?
Sure. The bankruptcy trustee is essentially a fiduciary for all the creditors. And most specifically for the unsecured creditors, which are essentially the great unwashed in most bankruptcies. But a secured creditor such as the bank, which has a lien on everything that this estate has, is a major party in interest in the bankruptcy. We are not the bank. We recognize the bank and the state, which is also a major, not as large a creditor, but still is a major creditor with very important standing. These are creditors that any trustee has to work with, to have a working relationship that is productive, and essentially shares this goal, which is to liquidate property, to turn it to money, to take care of the claims. So in that instance, there's a confluence of interest, the bank and the bankruptcy trustee. I do my job if I preserve the operations as a Chapter 11 trustee. Unlike a Chapter 7 trustee, if I were a Chapter 7 trustee, it'd be just sell it, get rid of it. Chapter 11 trustee, I have to keep operations going and have to sell it, to turn it to money, to pay the creditors. And so, and obviously the bank, as the level of its claim, is a major player in that job.
So playing it out, if the property is not able to be sold for whatever reason, and then what happens with the bankruptcy proceedings? Everything then there'll be nothing to pay off creditors, and then it will revert to the bank as through the foreclosure process?
Well, the sort of the what ifs on a worst case scenario. I think in short, that's that's not an inaccurate sketch of what could happen. Technically, if the property is abandoned, basically as a trustee, if I can't keep the thing operating, I have no equity, there's nothing there for the creditors, then abandonment, which puts it back in the hands actually of the debtor, Hawaii Outdoor Tours, subject to the bank's rights and remedies in state court. And that's where this game started back in November of last year, on the day that a motion was pending in state court in Hilo to appoint a receiver for the bank to accomplish what we're trying to accomplish in Chapter 11.
And the state, we have the first position on any funds that are generated from the sale?
The first position is the bank. And so that's another reason why I think there are some, and tax liens, I think prime, it's a priority according to it's according to state law priorities.
So we're third or fourth in line.
Yeah, but there is a priming of the bank's lien for real property taxes and for. I'm looking over at Tim Hogan, who's my attorney.
Do you want me to address it, may I?
Yes.
Yeah. Thank you. I'm Tim Hogan. I'm Mr. Farmer's court-appointed bankruptcy counsel. The state, we were talking about this yesterday when we were trying to sort of brainstorm, is in a successful outcome, or even an outcome that wouldn't be successful from, say, our perspective, the state is going to be paid in full. The state doesn't really have a risk because if the lease is lost, the bank is able to, in its mortgage protection part of the lease, to step in and cure and get a lease of their own, and that would pay the state. The bank, I'm not going to speak for the bank, but I would presume they'd rather not do that, but there is a mortgage protection that does protect the state. The state is in a position, if we go forward, and albeit it's been a bumpy road, but it's still a road, the state will be paid. If, however, the one scenario we did kind of posit would be if the lease is rejected, which would be tomorrow, will be Monday, the chaos that would ensue would put the state at risk. That is, my view. I'm a lawyer. I don't think many other lawyers would dispute that, because we become out of possession. Now, who's in possession of the hotel on Tuesday? Because if the lease is rejected Tuesday, there is at least an argument that the state's now in charge as the landlord. Do you want to run a hotel starting Tuesday?
You say the lease is rejected.
That's what we're here for. Let me just try to. This is sort of a bankruptcy concept that's a little odd. There's a part of the bankruptcy code that allows things called executory contracts and leases to be assumed or rejected, and it's to protect landlords mostly. It's other people in other kind of contracts, but it's a landlord protection statute, 365 of the bankruptcy code. It gives us in a bankruptcy 120 days to wait to see if we want to keep it. Typically, let's say a big company with 20 warehouses files bankruptcy and they want to get rid of some of their warehouses, they're all leasehold. They can sit there and scratch and say, let's get rid of this one, and they can reject it. At the rejection, it becomes a pre-petition claim, which is paid in little tiny bankruptcy bucks. If it's assumed, it then becomes an administrative obligation of the estate, and it's got to be paid in real money. So they give the debtor a little breathing time to decide whether to assume or reject. And in this case, it's really all we have is the hotel. There's no question that we want to assume it. It's just the question is that we typically do that in connection with an assumption and assignment. So if the bride shows up tomorrow and says, here's the money that'll take care of everything, we run down to the court, we file a motion, says we got the money in escrow, we want to assume the state lease, and the state's lawyers will
put in the state's case that says, well, this is what you have to do that, right? Which is cure the defaults and prove that the new guy can perform and isn't going to go into default right away. And then the bankruptcy judge can then assign the lease. And that is typically one of the major plays in every reorganization case. That's what they are there for. Typically, you don't go through this because the landlord they'd kind of always rather have somebody paying the lease rent and keeping it running than take it over. There are times when I guess it happens, it's very rare. In this case, bankruptcy code after that 120 days says we can only continue to have the opportunity to assume that lease and then assign it if the parties to the lease consent. And there's another lessor, the Blnr Trust. I don't know how familiar you are with a hotel, but there's a parking lot area, there's a pool. And if you look at Banyan Drive, it's the only private land on Banyan Drive. It was, I guess, an old beachfront piece of property, somebody's home perhaps at some point. So they've agreed that if the state agrees to extend it, then they'll go along with it because they want to get somebody to pay their rent. And if it's rejected, their claims become pre-petition, which in this case would be fairly much worthless. So it's the nature of this. Bankruptcy is a strange, magic kind of law that you can do incredibly great things. It's also got some real hard things when you miss them. And this is one that, as Mr. Farmer had said, the options to the trustee would be an abandonment or something of that sort, where essentially the hotel will shut down. It will shut down on Tuesday.
So one follow-up question is, on this reject the lease scenario, besides potentially putting us in a bad position, what happens to the bank?
Oh, I wouldn't. I'm going to give it my view. The bank's lawyers here. I'm not speaking for the bank, and I presume you know that. But the bank has a protection clause in the lease. There is a section of the lease because most of these large commercial leases that you folks have or the state has realize there's somebody's going to go out and borrow money to build something on the state property, and there's a mortgagee protection clause that allows the bank to send certain notices to the state to say that we want the lease now. And there's a process that goes forward. We haven't really looked at all the other things. I think there normally is a lease cancellation proceeding that has to happen because the lease being rejected from the bankruptcy doesn't necessarily kill the lease. It kills the bankruptcy, but it doesn't kill the lease. The lease is still a legal document that then goes generally to state court for a lease cancellation. It's land court, so it has to go through the land court to be recorded as a canceled lease. And through that whole proceeding, the bank would be the principal player because it's their collateral that's impacted. This is a complicated thing for bankruptcy lawyers. It's a simple way to understand it is what the code envisions is if we don't get the extension is we throw the keys in the door here on Tuesday. I'm not saying that's going to happen. That's what the code says. The trustee shall immediately surrender the property. That's what it says. So
For the assignment of the lease, not these extensions.
no,
that you're asking for today.
we're asking for an extension so that we can try to sell the property, do the assumption, pay the state, pay the bank, pay the other creditors, and be done with this case. Bring in whoever's going to go into this hotel is looking at $30 million of renovation, 20 to 30. That's a big renovation bill. It isn't easy to get somebody in an economy coming out of a depression, essentially, to pony up that kind of money. And we're doing our best. Maybe we could have done more, but we have people that are looking at it, that are hotel developers that do this kind of thing, and that we're hopeful. We have a first-class broker that's going to fill in and try to bring in more interested people. And there've been a lot. I talk to a lot of people on this hotel. I mean, the people call. They go out and look at it. Everybody's waiting. There's this thing that happens in bankruptcies where what we want to do is get a sale teed up, so that if people are interested, they have to come out, or otherwise it's going to be gone. It's the idea of the rejection of the lease is something that I don't think any of us have an experience with in one of these large commercial bankruptcies, where the major asset is essentially is out of the estate. We will not have any way to retrieve it if the extension is not granted.
So Real quick question. So what you refer to as the rejection of the lease is really the operations of the hotel. The lease still remains in effect.
Well, it's complicated. The bankruptcy is still in effect. So there is a bankruptcy, there's an automatic stay, all the things that come up from the bankruptcy. But the asset that we have, which is that lease, it is a valuable asset that is something we can sell, will have been rejected, which means we can't sell it. Now, will we continue to operate the hotel as a holdover tenant, or, you know, I mean, this is a bad bar exam question that I'm glad I didn't have to answer about what comes next, because it's just, there just isn't a lot of history on these things. I think the combined, there's probably 100 years of bankruptcy practice in here, and I don't think any of us have, in our practices, have ever experienced it.
Help me try to understand something here. The judge is the one who will be deciding on the assumption of the lease, right? Okay, in the bankruptcy, all right.
That is correct.
So what about the fact that if this board doesn't grant your request for extensions, how would that weigh on the bankruptcy judge to not do that? And also in relation, then the bank, for Citizens, is sitting here. They're the ones, you know, basically holding, you know, a lot of the cards and have the most at risk. Why wouldn't they then step up and cure these defaults so that they can keep the process moving on and avoid this chaos and all that?
Oh,
why are we having this, you know, why are we having to, you know, carry this weight?
I believe fully the bank will step up, but it's the period of time from Tuesday to the time that all that is completed is the chaos I was talking about. The bank has, you know, a duty to its own shareholders and to its own fiduciary duty to not allow its asset to be lost.
Okay, well, going back to the first part of my question is what in our action of not extending, you know, doing these extensions would force the judge to say, oh, well, then I'm not going to, this assumption lease is not going to happen.
It's automatically rejected on midnight on Monday. The judge has no role or function in it. It happens. The judge will only be, what we're contemplating is getting an emergency hearing before the court on Tuesday to tell him it happened and to tell him what we have to do next. It is by operation of law. Congress made the law. There is no way around it. It will reject, and then we cannot assume it. It is gone. It's gone and cannot be, you'd have to give us a new lease.
And it will be rejected because of the defaults?
No, because you didn't give us the extension. That if without the code is very clear that without your consent, it will be rejected on midnight on Monday. Unless you consent, and we rush out, we've already drafted it in hopes that we'll get a successful result there because we don't have much time, is to submit that order to the judge today. If not, well, we have to then decide how we're going to address what will probably be the shutdown of the hotel. I don't see.
You guys cut this pretty close.
That's my question.
Well, no, yeah, I understand that.
That's my question.
Yeah, and I was probably, you know, for not understanding the way the board operates and the necessity of going through a hearing like this to get the extension is a challenge. But like I say, it's. If like we don't have anything else, you know, if you don't approve it, then there's really no realistic plan B that keeps us as a tenant in the hotel, at least for the bankruptcy.
What about a 30-day extension? Give the bank time to cure the default?
Well, I would always, you know, rather than have it all die on Monday night, you know, we've asked for a longer extension, but to keep it alive a little longer, you know, rather than have it go, I mean, I'm not going to try to play hardball with the board, and I don't think that the trustees, I think, agreeing with me that that's what's, you know, that's all in the cards. I will say that we have explored trying to get it's complicated because of the nature of the liens on the property, to get an interim loan from someone as part of one of the interested parties to do that, to try to cure some of these things. We understand the state, you know, has fiscal responsibilities, and this is a lot of money for anyone. It's a lot of money. So we have been working on that. We had a conference call this week trying to, you know, field some ideas. we understand how that these are concerns for any landlord, is always wants to have their lease rent paid, and that, rather than have it shut down, if that's sort of a position the board could live with, we'd have to come back here and do this again and tee it up for the next meeting probably, if we didn't get a sale. Otherwise, we just need to have sort of a rational approach to what we do next. Because the trustee is essentially the hotel operator, and there is a staff there and there are people there that we have sort of to keep informed about what's going to happen. So the longer the better for us. But I do understand all the points that the board has.
I have a question.
Yes, sir.
When was the last time this hotel was profitable?
Depends how you define profitable. If paying your bills are...
Paying your bills and not owing anybody any money, and even if you break even, how many years ago, how many months ago, when was it?
I'm not sure if a case could be made that since this lease was in place, that it ever was profitable.
That it was ever profitable?
Not under this lease.
So basically then, if it was never profitable, how is it going to be turning around? And I'm hearing you, but it seems like we're in the fourth quarter. We're not going to, we're tie right now. We need to go into overtime, but it's not going to happen because you're not making money at it. And even at the extension, is it going to be of any value to you? So by extending it out to December or 30 days, I don't know if that's going to happen. Considering, have you read some of the testimonies that have been presented to the board of people in the community? I mean, there's people for it, but what I've seen, business people and other people are against it.
Let me just quickly address.
Okay.
The value of the property is what a willing buyer will pay us, a willing seller. And it's true that under current operations and the current mentality and administration of this property, it's been a loser. But that's not the way the rest of the world necessarily looks at it. We have two potentially substantial players who are willing to put their money where the mouth is, who see a potential in a frankly distressed property in a market that is not Maui, that is not Waikiki on fire, but see the possibilities. And that's all what a developer does. And it's finding the right person, and then we've certainly got it down to two candidates who will put their money where their mouth is. But that's the key, and none of us here can say for certainty that will happen in 30 days, 60 days, or 90 days, frankly.
Right.
But that's, whatever the decision is, if we have the extension of time, that will be pressure that we will bring back to those bashful brides in the back room to say, now's the time. Time's up. We're not going to.
When does potential buyers came to the game? When were they? How long have you been in negotiation with them?
Number 2 is the most recent one, I would say, happened in August, the end of July, or perhaps August.
Just last month?
Yeah.
Okay.
Yeah. And the number 1 folks,
June.
probably June.
I think it was June.
And they
So
were,
just within the last couple of months?
absolutely.
Prior to this, you had nobody?
Well, we had inquiries, as
Right.
Tim says. We get calls. We get again the local usual suspects who
It's like
would be
fleas on
interested.
dogs.
But who are bottom fishing?
Okay.
What is the property, what's Collier gonna list it for?
We're not going to, we don't want to set the price and say, here's a hotel for this price. We want to get people interested. They need to go look at the hotel and to make a bid. And we're not going to simply say this. We understand, what it takes to cure all the things. I live in this spreadsheet world, but we're really hesitant until we see what the market does is to come in with a price. We've had, it isn't like selling a single family home. People who are going to do this are going to have to commit to a tremendous renovation expense. And to address your Board Member Gomes' inquiry, when this hotel, when we first started this hotel, its average rate was mind-blowingly low to me. I used to work, before I went to law school, I was a hotel manager. All right, I worked in Waikiki. And so I kind of know the basics of hotel, you know, reading the report, and I couldn't believe it. And I did a couple of things. I called to try to book a room. This is the first day I was on the job. It was sold out. It was empty in reality, but I couldn't get through. There's so many things that were just, you know, jammed up. To make money in that hotel, the rate has to get up to, it's not going to be Waikiki average rates. It's not going to be, you know, the sort of the Gold Coast on the other side of the island, you know, and the, you know, the sort of super hotels that are on the Kona side. But it's got to get better than the rate that's there for anyone to run it profitably. Once the rate is up, you've got the most, if you don't sell a hotel room at night, you can never sell it again. You have so many rooms, you need to sell them at the highest possible rate, and that's your revenue. A renovation, and not just this hotel, Banyan Drive needs this has to be the beginning of Banyan Drive's sort of ascension for this hotel to be a success. You don't want to be the best hotel in an area of rundown hotels. And I believe the people that I've spoken with at length, that is their hope. They see it as an opportunity for this entire region to advance. This whole part of Hilo. It's you know, there's 70 acres of golf course there. It's right almost in the middle of downtown. It's you know, not too far from the airport. It's got all the pieces that you need. But when we came in, really towards the end of May, we didn't know anybody. The one thing we have to be when we get hired in these cases is that we don't know anybody. And we don't know anything about anything. It's called disinterestedness. And we have to sign this and swear that we don't know anything about it. And so we come in with new eyes. And we're trying to pay the creditors, and we're trying to keep the hotel operating. If we were going to have to, you know, reorganize it and fix the band, we got to get a buyer in there, and they will do all the things you're talking about. They're not going. The people we're talking about are not thinking about investing this much money simply to lose money. They're just not. These are you know, people who want to turn a profit.
Can you refresh my memory on when the walkthrough inspection was that you were mentioning earlier?
It wasn't the one we were talking about. There were a company that we've been dealing with, and I think this is what you're talking about. They actually stayed in the hotel. They were there. It was 10 room nights. I'll talk in hotel speak, which is, you know, 2 people times 5, and they met with a number of people. One of them is a contractor. So it was able to, you know, hit the ground. I believe they did speak with Hawaii suppliers and contractors. They were talking about getting materials. I mean, they have a plan.
Sorry, my question was, when did that happen?
When?
It was in July.
July, I think.
And we also had a meeting with the mayor.
It was right around the same time. They actually met with the mayor.
Right.
Sorry, I didn't mean to not answer your question. I apologize.
No, thank you.
Further questions?
Yeah, I'm sorry.
Okay.
Just on this recent line of discussion we had, these new buyers are aware that, you know, what they're buying too. They're buying the lease, and that the lease under state law is not, you know, is not able to be renegotiated. And that $500,000 base rent is somebody's going to have to live with.
Yes.
Yeah. So I just want to bring that up. And then going back to the extensions, if miraculously, you know, a bunch of cash flow came into to the hotel operations, or a chunk of money fell out of the sky, and you guys this afternoon could cure these defaults, then what would happen on Monday with the bankruptcy judge and the assumption of lease?
Even if we were to write a check today to pay all the defaults without the extension, the lease will be rejected. It is federal law. There is no other way.
You know, let me just, because frankly, it was a little confusing to me as well. When we're talking extension, there's two extensions. One extension is the extension to pay, right? The other more important extension that we're talking about is the extension of time for us to assume or reject. Now, those two dates, those two extensions are coming at the same time, Monday at midnight. But the one that's going to be a killer of this estate's ability to go forward is not the money request, but is the request for the extension to assume or reject. Because after that, bankruptcy, I don't have any bankruptcy court, nothing, it's gone, and it's shutdown time. So that's just, we're talking two different kinds of extensions there.
Okay, I think I got it. So, in reading the bank's attorney's letter dated September 6th, they mentioned these three things: extend the time to assume or reject the lease, the lease payments that are due, and this performance bond.
Right.
Extending them all to the end of the year. They go on to say in their letter that the only way that the monies that are due we're going to see is for a sale of the property.
Correct.
And it says right here, the only way. I think there's another way, isn't it? Can't the bank cure these defaults?
Rich uncles can always appear in people's lives, but
Do you happen to know what, I mean, First Citizen got this loan from another bank that was falling apart, and the FDIC, I guess, had First Citizen step up and buy it.
that's correct.
And they owed, it was a $10 million note or something like that.
That's
right?
correct.
So they got, there were penalties and interest, so it's something greater than that.
Right.
Do you know what they essentially paid for that note?
I do not, and again, if any, those particulars about the bank's counsel is here and they can maybe address those. But once again, in a way, it doesn't matter, because if you pay 2 cents for a note for $1 million, you got $1 million claim. So, I mean, that's
Well, I
just,
know.
that's the law.
I
You know.
understand, I understand.
So,
it seems to
now,
be
whether or
they
not-
potentially have a, if they bought it anything less than par, then they have a
Yeah.
keen interest in keeping this going.
Well, and I think underneath the question is the question of have we asked the bank to step up? Yes, we have.
And
And
they've-
thus far, the bank has declined. So,
Well, yeah,
that's the
it's
long
like
and
the
short of that
bank.
question.
Yeah, in the rejection, the bank will more than likely, and I'm not speaking for the bank, step up, pay it, but the bank will become the lessee, not us.
And it'll be in state court.
Well, if we reject it, but if we extend the, extend the deadline, we don't reject it.
Right.
But
Then-
we say pay up by one day.
Monday.
Whatever, or a bank can wire a
Take a
check.
check.
They wire the money instantly.
Jim to Wednesday.
Yeah, just in case, something happens on
Well,
Monday.
strictly, wearing my trustee hat, I would, if we could prompt that to happen, that would be great. But I'm not optimistic that that scenario would play.
I
That's,
think they'd pay.
The bank, not to speak for the bank again, but just from a commercial perspective, the bank would be in better shape allowing the rejection and get the lease for the bank. We're out. There's no bankruptcy in the way, and they're now the owner of the hotel. So if it's kind of like putting a gun to your head and saying, don't move or I'll shoot, the bank will end up with a lease and end up curing it, not next week, but there'll be no hotel operating on Banyan Drive in the meantime. So,
Just a little bit, I mean, it's nothing to do with the extension. And is the room rates at the Nane Loa comparable with the Hilo Hawaiian?
I didn't do a room rate comparison. I look at the rate, that's a blended rate when I see the reports, and I'd have to see the other hotels' report, which are never going to show a competitor. I would.
No, but you would call, I'm inquiring, I want to stay.
their rack
number of
rate.
X days, a rack rate or something, And they just came to us and they just had a lease, an extension of their lease.
They're renovating.
Hilo Hawaiian, for renovations and so forth. They weren't here for what but you're right next door to each other, so
Right.
Yeah, I would think the rates are fairly, there's
The
competition.
rack rates are comparable.
Yeah, I think they are, right.
That's
But-
my understanding.
But when you get down to the wholesale rates, because those are the ones that are negotiated directly with the wholesalers, and that's where the sort of the wiggle room can be in the rates.
Okay, thanks.
Any further questions? Okay. Would the attorney for the bank like to come up and add anything?
we appreciate your time, gentlemen.
Thank you.
Good morning, Mr. Chairman. Good morning, board members. I'm Ted Pettit with Case Lombardi and Pettit, and I am counsel for First Citizens Bank. I don't have much to add to the testimony, but I'm certainly here to try to answer questions.
Questions from the bank?
Same question when they left off.
Okay.
Would you assume if didn't do the bankrupt, I mean the extension, would the bank take over?
The bank, since a default last summer in the failure to pay rent, which resulted in the performance bond being drawn down at that time and a request for the bond to be replenished to the $500,000 mark, the bank advanced those funds. That was approximately $250,000. Subsequently, the August rent became due for last year, and the bank advanced $262,000. So we're out over $500,000 in simply trying to preserve the lease. Those actions were taken under the mortgagee protection provisions in the lease. So I can't tell you what the bank will do in the future. I can only tell you what the experience has been. And there's a separate mortgagee protection provision if the lease is rejected and terminated. At that point, the bank has the right to request a new lease. And I think that's what's been alluded to.
Is that federal bankruptcy law or
This
state?
is in the lease. This is strictly a mortgage lender protection provision in the lease. I think everyone here understands it, but from the bank's point of view, this hearing is required because the landlord's consent is required for the extension of the lease. And it is absolutely true that the bankruptcy court cannot do anything about extending the lease at this point. That power is simply not there, and it's intended to give the lessors the ability to make these kinds of decisions.
Okay, so I want to be clear. So the bank believes that under some mortgage protection clause, that should default occur, that the bank has the ability to capture the lease and to renegotiate the lease?
No.
No, okay.
We have the ability to request a new lease in the event that the lease is terminated. I believe it's a 30-day period for the bank to make a request for a new lease.
With the same existing terms, it's just a assignment of the lease to the bank entity.
Yeah, I think that's accurate, although the lease talks about a new lease.
Under same terms.
Correct.
Under the same terms.
That's
Correct.
the language.
Yeah, time remaining as well as the economic terms. Correct. Okay.
Just wanted to make
All
sure
right, good.
we're all clear that that is the case.
Anything else?
Anything else? Any other questions?
Do you think 3 months is enough time to
Um,
experience, or what you understand
the-
what these transactions might be at?
Bankruptcy transactions can go very rapidly. You might remember the Maui Oceanfront Inn was in bankruptcy a couple of years ago. We had the same problem. Lease was in default. We closed that transaction in about 30 days. So it is a transaction that can occur very quickly. The requested deadline to the end of the year was really the judgment of all of the stakeholders, the bank, the state's council, there's a committee of creditors which has counsel, and the trustee. So we think that's a reasonable time frame to get things done.
Any further questions? Thank you very much.
Thank you.
I noticed Mayor Billy Kinoy in the audience, and I know you would like to testify. Hello, Billy.
Hello, David. How you doing? Good to see you. First of all, hello, Mike Kako, Mr. Chairman, Bill Ayla, distinguished members of the Board of Land and Natural Resources. Greatly appreciate the opportunity to come and speak on behalf of the property in Banyan Drive That is the subject of our previous conversation. Nani Loa. I have a lot of respect for David Farmer, our bankruptcy trustee. I've asked him very straightforward questions and got very straightforward answers. I don't appear before any of you as an adversary to the proceedings of bankruptcy. I sit here today as an advocate for my community. I live in Hawaii Island. I live in Volcano, but I work in Hilo every day. I've seen the condition of Nani Loa for 7 years. And anybody who's proud to call Hawaii Island home, it breaks your heart every single day to see what it looks like in Nani Loa. The county is responsible for properties on both sides, on either side of Nani Loa. We just invested in creating Reeds Bay Beach Park. It was very popular with our families, our community, our kapuna, our children. We put in new comfort stations and bathrooms, new grass areas. And that'll be on the Puna side. On the Hamakua side, of course, we're responsible for Coconut Island or Moku'ola, Lili'uokalani Park, showcase places for our community. But in the interior on Banyan Drive, it is the kuleana of this board, the Department of Land and Natural Resources. To describe the condition as deteriorating is generous. To describe the conditions as deplorable is more accurate. I have the honor and privilege of serving my community as mayor for 5 years now. For 5 years, the condition at Nani Loa has held East Hawaii economic hostage. The second most popular visitor attraction in the state of Hawaii after Pearl Harbor is Hawaii Volcanoes National Park. Incredible opportunity to stimulate the economy, to create jobs, to have an ancillary benefit or multiplier effect throughout the East Hawaii community because of that visitation, tourism, through visitors and residents alike. But none of that happened. 7 years. Each year has gone by. It's become increasingly embarrassed to call this place our home. We just celebrated the 50th anniversary of the Merry Monarch Festival, probably the showcase event in Hawaii. The Nani Loa was charging over $300 a night. If I can pass around these exhibits. When the Nani Loa was recently cited for safety violations of their kitchen, this is what they did to replace the kitchen. I spoke at a state convention there a month ago. I cannot even describe to you the embarrassment. To be able to welcome people to beautiful Hawaii Island. And if you look in the back, this is a spectacular area, you guys. I run through this area at least 2-3 times a week during my lunch break or early in the morning. Every day I run past, think to myself, how? How this one happen? That's one kitchen of a volcano resort? Who would take their family eat over there? $300 a night? State conventions come, who coming back? People come from Japan, they're never coming back Hilo again. People now stay on the other side of the island, drive over, visit volcano, go back. Drive over, take a helicopter tour, go back. Drive over, visit the beautiful botanical gardens, and go back. Well, everybody suffers. Why? Why everybody suffer? This is the hotel, you guys, and I'll pass this around. This is the Showcase Nani Loa Volcano Resort for 7 years. Look at that. We go over there for special events because where else are we going? You know, Hilo Hawaiian right next door putting $17 million in, but they're always full. Aramea, and I'm even connections for get my friends in over there. You guys call me up, hey Billy, hook me up with an hotel. No can. Back full. Look at this. Every condition. The LNI employees, this is our report. How the oversight for the last 7 years allowed this to happen. Where was the insurance of compliance? That's one entire tower, you guys. Look like that for 7 years. Showcase piece of property managed by the state of Hawaii, the board. How? How that? Every day. This is commercial street frontage right here. You know. This is where everybody comes. This is where our families play. Powerless, helpless. Many years I've sat with Bill Isla, who I deeply respect for many years. I've come, I've met with DLNR staff. You know, local style, especially as a leader. I think Japanese get a saying, the taller the stock, the lower you bend, right? Be humble, be respectful. You know, I don't call the media, I don't hold press conferences. try to build relationships. I try to advocate for my community as respectfully as possible. I've met with Rob, you know, tried to, hey, help us out, man. People suffering. You know, as a mayor, you're the leader in the community everybody talk to. And I don't cruise around with entourage staff. I drive myself every day. You know, I walk in a community. People stop me in the supermarkets, at the soccer field with my kids, in the water while I surfing. Except if big, I tell them, oh, you gotta hold on, bro. We cannot talk right now. But look at this, you guys. This is, how can you say anything but shameful, disgraceful, deplorable? And if you go from the ocean, you stand up paddleboarding, worse. What I'm showing you is all pictures from land. You go from the ocean, you wonder. You know, I sit with George Applegate. He brought me the old newspaper clippings when the Naniloa went open. This is everybody. Try imagine as the mayor, as an advocate for 187,000 people on Hawaii Island. You gotta welcome people to your beautiful island. And in a challenging economic environment, our assets need to be closely guarded, right? Ensure compliance. You know, one time when we had the worldwide voyage blessing, our respected and revered navigator, Nainoa Thompson, said something. It made me turn and listen and said, "You're absolutely correct." And what he was saying in the blessing of the voyage was, as a navigator, and I take that as a leader, your first decision is the most important one. If the first decision is wrong, every decision after that is wrong. This lease was appraised at $150,000. Blnr, in trying to get the highest lease rent per year on the board, when let an operator who's lost a volcano resort, and nothing against him, it's not personal, lost 90 Mile, and managed that property as you see, into the ground. Standing right there was Outrigger, standing right there was Starwood's Resort, each of them with $30 million to invest, upgrade the property, long-term lease. You know how much jobs we'd have today? Absent this hotel operating properly, our employees drive 4 hours for jobs in South Kohala, where 83% of our resort development, but the people who work there cannot afford to live there. So they live Hilo, they live Puna. That place is supposed to be thriving. But we allowed this $5 million over 5-year investment. Really? And the current lessee stood there and just outbid all qualified hotel resort property managers. He just bid it up, 300, 400, 500. These guys looked at each other, Outrigger, Starwoods, and said, we cannot pay that kind of lease rent and make one viable resort, hotel, hospitality, business run properly. So they all walked away. One guy got them. And the oversight has been poor. It's not one finger pointing, it's not an excuse, not one blame, it's some fact. He had a $1 million performance bond that they let use to pay the lease rent. That wasn't for lease rent, that was a performance bond to ensure compliance with the lease. You know, and I respect the council here advocating for the bank, for trust, but that's not my interest. To me, if I might borrow 3 things here. No simple, this is my quarter. I'll borrow a couple of things. State of Hawaii, bank, lease. The lease is between the lessee and the state of Hawaii. The bank is advocating that this lease is theirs. But in language in the lease, it says, failure to comply, the state can terminate this lease. Can terminate this lease for failure to comply. Now we hear potential scenarios that question the logic of that decision, but I ask, what other decision is there? The violations that occurred, the inspection, I have my assistant fire chief here. It's a daily disgrace, Naniloa, what is happening. What I'd like to see on behalf of our community is a termination of this lease. Cut this lease, 500,000, nobody gonna come in. That's why we get this bashful bride failure to come up to the altar, which is a great line, by the way. But hey, all that aside, no one worked this lease. I know Blnr and looking out for its responsibility wants the highest and best rent, but 500,000, Outrigger walked away already years ago. Starwoods walked away. Who do we want to come in there? Somebody just for invest a little bit, save their investment as much as they can so they can flip and get the most out of it. That's not what I like. What I like the state do is exercise some leadership. Admit, acknowledge past decisions, mistakes that were made, and say our community, Hawaii Island, East Hawaii, deserve better. Terminate the lease, start again. Now the bank say they own them, really. I mean, the county, I like step up and buy them. I cannot live like this every day and wait 6 more months, 1 more year, 2 more years. 5 years I've been mayor. Quiet meetings, trying to resolve, ensure compliance, investment and repair, maintenance. We're not looking for a 5-star property. We're just looking where families can work, where visitors can come, have clean, reasonable accommodations, where the multiplier effect economically ripples throughout our community. And Banyan Drive is restored to the beautiful, special place that it is. You know what they put up? They put up hog wire around the golf course parking lot, ban everybody from using them, kick out the junior golfers. Nobody use them anymore. And yet it's surrounded by beautiful Liliuokalani Park. Everybody walk and drive and play through there. And every day we gotta look at that, and hear one excuse, not a story, right around the corner, we're working on it, it's out of our hands. I mean, I've sat with the AGs, the governor, pleading for help, pleading for my community, pleading for my home. Enough already, you guys. How much longer this gotta go on? You know, this one jewel of our community. You know, this one asset for our people. This is an economic driver for a community that needs every possible support it can have. Not so we can have higher property values. Fortunately, the county, you know, we don't can hit the state, so, you know. But it's so our working families can live, work, and play in a special place. You know, we're not here for say it's somebody's fault. Somebody was wrong and somebody was right. It's not my position today. My position is, members of the Board of Land Natural Resource, our distinguished chairman, please help. Please help us, help our community. Hey, if we struggle, I would love this. Give them to the county. Why? It's not one state county issue. Our kids in our community, they're not state county kids. Our working families, they're not state county working families. They're ours. We all share the same responsibility. The bank like go, hey, I'll go with the bank. You know, like litigate. I went law school. I'm not quite sure about bankruptcy code, but I'm willing for court, fight for my community, stand before a judge, explain what happened, explain where we are, but more importantly, articulate where we need for go. Now for it, I cannot stand by and watch this continue. I fail in my fiduciary responsibility to my community. Standing by any longer, I fail in my role as chief advocate for the people of Hilo, Moko, Keawe, and Hawaii Island. Standing by any longer, I'm not fulfilling my responsibility to the 187,000 people who call Hawaii Island home. So I'm happy to answer any questions that any of you might have, and I appreciate the opportunity to speak before all of you today.
Any questions?
Yeah, I have a question, Mr. Mayor. So, as far as, I know we had inspections by the building department and
Yeah.
the fire department, and we had a lot of things that were in compliance. So as far as you know now, everything at that hotel is actually in compliance? I mean, you look at these pictures, it's hard to believe that.
Everything is not in compliance. Rob, I could go in and shut this down. I could shut them down Monday. I was going to shut them down yesterday, make your job easier today. But they're making good faith effort. You know, they got to drill, they run on pole through multiple floors. They just drill on puka all the way through all the floors. You can stand there and look up to the floors. They get on elevator, one elevator in this whole hotel, one working, with a sign that says temporarily out of service, but been there for 2 years, year and a half. You press the elevator, you go up to the 10th floor. If they don't press ground level, the thing's stuck on the 10th floor. You know, minimal staff. You said a kitchen, eh? Rob. They never repaired a kitchen. They no more hoods, they had safety problems in the kitchen. So to solve the safety problems, they didn't build that and cook outside like that. I mean, you could say technically they're working towards compliance. That's shameful that. We'd let no other hotel, I asked my inspectors, you let any other hotel get away with that? No? Then why are we doing them in this case then? And I'm trying to protect jobs, but at this point, we causing more harm than good with this hotel. You should have seen the embarrassment on that state convention attendees. I was embarrassed. And when I made a joke about a calamai for the hotel conditions, the whole place and laughed. People were pulling me on the side asking me, whoa, how come smell of that? How come this thing's still open? One swimming pool with green algae water in them. Not for 6 months now, not for 1 year. 4 years, 5 years. So, in answer to your question, are they in complete compliance? No. Yesterday, my public works director said if we wanted to, I could close them down, would be defensible. But if you want to keep them open, you could do that too, because, you know, ensuring that they're making progress. You know, they're trying to address the issues. So it could go either way. Could go either way.
And that's where we sit today. So we have, you know, we have these decisions to make, and one decision could mean that the hotel could be shut down, you know, next week. And another decision could be to try to keep working forward to some resolution of this. And yet, you know, I agree with you that the lease is inherently faulty. The lease also is, the acceptance of that lease through the bid process was something that DLNR said, you know, we're just out to get the most money. It's their state law that requires us to.
But Rob, I disagree, because you could have put in the lease that you needed to be a qualified buyer to bid. And to be a qualified buyer, this board could have defined what constitutes a qualified buyer. And you could have said you need $10 million in a bank or credit line that proves that you're qualified to manage this property. Yes, highest and best use, but if that's on justification for the highest lease rent in lieu of destroying one asset in our community and let it run down for 7 years, then I would respectfully disagree. That it's not just the responsibility of getting the highest and best rent. It's about ensuring the viability of the asset. The board has much more responsibility than highest lease rent.
I totally agree. What I'm saying is that, you know, by the way that the state statute is written, and the procurement process does not give the department the ability to do those type of things in the way that the law is written now. That's just a fact. And so,
Rob, the lease did require a $5 million investment over 5 years. You can define what constitutes a qualified bidder. You can define that could have been more money in a shorter period of time. So I hear what you're saying. I'm not here to get into a discussion with you, Rob. I respect what you're trying to say, but I'm not going to sit here and say it is what it is and it's got to be what it's got to be, because I've heard that story already, and I don't accept it.
I appreciate that.
Yeah,
Actually,
you know.
so my question to you is, from your, as
Terminate the lease. The lease rent is not viable. You're not going to get one suitable vendor who come in.
Okay, so let me answer your question.
Yeah.
We've asked our top attorneys those questions, and the answer has come back, bankruptcy, that's not a possibility. So rather than talk about what could have happened, what should have happened, we're in the process of what can happen in the next month or 2 or 3 to try to achieve what you're trying to achieve.
Bill, if we just go through bankruptcy, then a $500,000 lease rent stays in place, because their job is to protect all creditors. And DLNR at $500,000 a year lease is part of that creditor. That lease remains at $500,000. You still, let's go back to what I said, your first decision wrong, every decision after that wrong. Trying to maintain that $500,000 a year lease is based on someone who used that very same provision to take an asset away from very qualified bidders and run this asset into the ground.
Which Billy was legal at the time.
No. And so what I'm saying is the termination of the lease takes it out of bankruptcy, takes away the $500,000, because you're terminating the lease for non-compliance. You're turning in the lease for failure to pay. That's my sense.
So we agree. That's your interpretation.
That's my position. That's mine. Yeah, I'm sorry.
Yeah.
I'll leave it to the smarter guys who specialize in this.
Well, we received advice from those guys. So.
Yeah, but you know,
according to
I get some smart guys too, you know. You know, attorneys, you can sit them down. Black can be black. You question them some more, come white. I talk to them some more, move back to gray. So, Bill, what I'm saying is they all get positions, Bill. You know, it's not one slam dunk.
No.
That's their interpretation. there's other interpretations
And
too.
we're here today, and we're gonna make a decision.
Right, na, and so, mahalo, you guys, not here,
So quick one,
step
Mayor.
away. You
If I
heard
may.
from me.
Thanks, Mayor. I
Yes,
really
David.
appreciate your passionate testimony and your position. So we're really faced with a 3.5-month gamble. You know, is the bashful bride willing to take this $500,000? I don't know how we're gonna decide, quite honestly, but if we decide to give them any extension at all, hopefully, the county, Mr. Lee, the fire folks, will also give and see some progress, give a reprieve here too, and work together, find, if there is somebody, if they're willing to do it. We're gonna find out in this 3.5-month period. After that, I know my appetite for any extensions is gonna go way down. So, you know, I'm hopeful if we do some kind of extension, you guys will work with us.
We'll take a look at that. You know, we'll take a look at it. If we, as I said, we've spent many years, our style is, hey, nothing good happens unless people work together. You know, when we achieve desired outcomes, objectives, and goals, it's because people collaborate, cooperate, and work together. You know, we've always been in a spirit of working together, but you know, when you walk down one road long time and people say little while more, pretty soon, you reach a point and it's one more time. And if that's what it's going to take to achieve a desired outcome, then we'd certainly look at doing that. You know, we're not out for hurt nobody, certainly not our community, certainly not the department, you know, or the board. But, you know, I guess my request would just be, then let's set a deadline. Let's make every effort to ensure that we all get there. And at some point, you know, that's leadership, right? We all got to make difficult decisions. And, you know, sometimes, you know, but I'm thinking a difficult decisions, something will happen. So I'm open to it. But yes, it's been a long ride, and you know, it's a constant downhill, and a slide just gets steeper, you know. As the bank struggles to make payment, deteriorating conditions continue. Hilo Hawaiian Hotel every day get people who walk across going, excuse me, can we check in? We didn't know it was like this. You know, people, I mean, it's on black eye. You know, people not coming back to Hilo after that experience. You know, so it's keeping it open to keep jobs.
We understand.
Yeah. So.
Can I ask a question?
Yes, aloha.
I'm open going.
Yeah.
They mentioned that the potential buyer came and met with you.
Yeah.
And can you give your impression of how that meeting went?
Well, I met one of two. I also want to convey to the board that the current operator also has an investor group too. So that's concerning to me, right? If I get one chance with the current operator, come in under this extra time, pull an investor in, and grab the lease again. But the party that I did meet, as I meet with all parties, and I said, by the way, aloha, and aloha for you and what you do too. You know, they was looking for some specific assurances, and I was like, hey, bro. You know, bro. What do you mean? Yeah, hey, what? I can get this, that. I was like, easy, Tiger. You know what I mean? You come over here. You know, my position's always the same with potential investors. I say, we don't put up roadblocks. Any investor who comes into our community is going to create jobs, is going to be a good community partner, is investing for the long term, not a quick profit or quick flip. That will look to assist, facilitate, and help you guys out. You know, we're not going to change the rules of the game. I know all investors look for predictability and certainty. If you sit down and we lay out what it is you want to accomplish and how you want to get there, I will certainly work with you and ensure that you receive what you need in a timely manner. As long as you dot every I, cross every T's, we're not going to, you know, put up obstacles, hurdles, or barriers. So we're two brothers. You know, they were, you know, guys who answered questions. They were looking for more than they were going to get, but I encouraged them to stay in the game. And if they're successful, you know, we look forward to you coming and helping rehabilitate, invest, and create a, you know, nice accommodation in the community. So, you know, hard to assess in one meeting. But David called, and if Dave calls anytime, you know, I'll assist. Dave, I'm a good guy. Smart bugger too. So, but I still don't believe him. But you know, I told him earlier, hey Dave, you get guys in the community, bring them. I like meet them. I like look them in the eye, ask them a couple of questions. At least get on read on them, man.
Get a pulse.
Yeah,
I
just
guess
get the
that's what I
pulse. That's all I could
wanted,
do.
was your read on whether or not you thought maybe they had the potential?
I mean, get chance. Those guys get chance. Two brothers. What their names? We don't
Gillespie.
Yeah, Gillespie boys. Yeah. Out of Florida. What is it?
Florida.
Out of Florida. Yeah. I mean, get chance. If those guys could pull them off, yeah, I'd be happy. But still a lot of uncertainty there, right? Anybody could swoop in. Now I said, can you imagine? I gotta sit there, come out of bankruptcy, and a current operator go and investor, and they all look at me, and then everybody go like this. Oh, sorry, bro. No can help. That's bankruptcy. Oh, sorry, no could help, but the lease is the lease. Oh. I wanna have everybody marching out there. Hey, ho, ho, you got to go. You know. Nah. I just kidding.
I get that every time I go Hilo.
No. You good, Bill, but you're doing a tough job, brother. I respect what you do, brother. It's not easy, your job. This whole board's job. You know, you guys gotta manage very important lands.
I want to say something to you, Mayor. Thank you for coming in and speaking to the board. I think your testimony, your pictures is 1,000 words, you know, and to see the conditions, it gives me a whole new light as far as what the whole picture is. But I appreciate that.
No problem. Thank you very much. Thank you, board, for the work you guys do. Aloha.
Yeah, Aloha again.
Aloha.
Thank you.
Okay, no one else has signed up, but I'll start on the left side.
Caught in line there, bro.
I was just merely responding to the question. Yeah.
Good morning, Chair.
Good morning.
I passed out written testimony. I'm George Martin, representing ILWU. But I'll highlight because my illustrious mayor took some time, and I know you guys are probably a little bit tired sitting over there, so I'll just highlight the letter. I believe it was sent to you earlier too, via email, but Hawaii Outdoor Tours has failed to demonstrate its financial ability to support property from the beginning. Naniloa, as our mayor indicated, deserves a more financially capable steward. You know, the responsibility that you folks have as stewards of the land, of all lands, is just that. And the importance of that particular property. And I remember as a young man going from high school, different things, we had our proms there and stuff. It's deplorable, to say the least. Since Hawaii Outdoor Tours took over the property in 2006, the Naniloa has gone downhill, with the physical plant seriously deteriorated and major areas in the facility closed. When Hawaii Outdoor Tours took over, they laid off 80% of the workers. The employees were ILWU, and some of them have been there some 25, 30 years. They've gone through hard times and good times with the organization and with the previous owners of the properties. Hawaii Outdoor Tours has been given ample opportunity to restore the Naniloa, but has failed. Let's give someone else an opportunity. As if there is somebody in the pipe, hopefully they come through sooner than later. As the mayor indicated, he's willing to take a look at if there is possibly an extension. That'd be something that he'd have to do. We don't feel that it should be. Again, Hilo deserves much better. And that's about it. Any questions?
Thank you, George. Questions for George?
Have your existing employees of the non-law, if they are in
Non-union.
non-union. That's all I need to know.
Okay, any further question? Thank you, George.
Aloha.
Anyone else on this side wishing to come up and give testimony on this agenda item? In the middle portion?
I also have some written.
Okay, would you hand that up to the board? Anyone else on this side, the right-hand side? You want this up?
Dan Purcell, and I'm going to say it as I see it, whether it makes everyone in Hilo happy or not. I first landed in Hilo, and so I have some experience there. And I have absolute respect for Mayor Kanoe and Council Members Yoshimoto, Onishi, and Council Member Poindexter. But let's face it, let's keep all this in context. People don't want to visit there for a whole variety of reasons. It's not just this hotel. Yeah, the hotel's been poorly managed. Banyan Drive's a bit of a mess, but that whole area has some problems. Mayor Kanoy could have taken pictures anywhere in Hilo, and it would have looked just like those pictures. There's graffiti everywhere, there's mold everywhere. You know, it's not the Gold Coast of West Hawaii. Let's face it, that's where people are staying. And I brought it up, a lot of the historic buildings there are absolutely awesome. It's a walking town. You can get around and do things, but they're not taking care of them. It's peeling paint everywhere. Like I said, graffiti, mold everywhere. I showed up with a pressure sprayer and a wet dry vac, and I was intent on cleaning the town up myself. I went in and tried to clean up the local park there. 3 police officers showed up, told me to stop cleaning the park, tried to volunteer to clean the park up. There was no interest in the Parks Department to let me clean it up. They could have a nice oceanfront walk out there. They don't have it. You know, they just have a bunch of parking. They're using some of the oceanfront parking there right in the downtown area where all the hotel employees for the Gold Coast go park for free all day and ride the bus over to West Hawaii to work in the hotels, and they clog up all the parking down there. So there's a lot of things they can do, and they're not doing it. So, you know, keeping all this in context, they've got a lot of work to do there to get the whole area cleaned up, in my personal opinion. And just as kind of a side note, it's a little rough there sometimes. I mean, I don't hear much in Honolulu, but I heard a lot of howling and screaming and cussing and stuff, and there's a lot of issues there that makes a lot of visitors feel uncomfortable and unsafe, and there is a lot of crime and such there. I was there for 2.5 months and was real active, so I absolutely love the town. I have a lot of interest in seeing that Hilo, the future of Hilo. I'm excited about it. It's an absolutely awesome. It has a lot of deep roots in Hawaiian history, and but just jazzing up this one hotel is not going to solve the problems. But this hotel does need a lot of work, obviously, and I'd like to see that whole area revitalized. Thank you.
Any questions for Dan? Tina, thank you very much. Want to take us into executive session?
Yeah. That's it for testimony?
That's it. No one else?
I'd like to move to go into executive session to discuss with attorneys questions and issues relating to our liabilities, powers, duties, privileges, and immunities.
Second. All those in favor say aye. Aye. Okay, the land board is back in session. Board members, discussion? Or a motion so that we can have discussion?
This is really tough. I mean, we're in a really difficult position here. And I think there's things we'd like to see done that, you know, we have constraints within the bankruptcy proceeding processes and federal law that oversees that. And so there's not any great decision for us, but I'm going to, after our discussion, make a motion to deny extensions on all 3 issues.
Do you have a second?
Second.
Okay, so we have a motion and a second for discussion. Board members, any further discussion?
I mean, what can you say? This is it's really difficult. We looked at every possible angle on this, I think, in executive session. We get federal law, state law, and finally, what's best for Hilo in the long term? We know we still got to go through some pain. There's no pain, no gain. And long term, what we think is best for Banyan Drive, Hilo, East Hawaii, Island Hawaii, and probably the state is to do this. And so I'm going to vote in favor of the motion.
I know by doing this, we're forcing several things to happen down the line, but frankly, no matter what, we're going to end up with some tough decisions down the line also. And so I think this is the best course for us to move things and force things along in the most expeditious manner to try to resolve the situation out there. And hopefully, some way bring that property up and maybe possibly have a different lease there in place that makes sense in the long term for the department and for Banyan Drive, for the county.
Thank you,
Yeah,
Rob.
it was Mayor Kinoy's presence here and his willingness to accept the short-term difficulties that are going to come as a result of this decision that made me willing to go along with with the motion.
See no further discussion, I'll call for the vote. All those in favor say aye.
Aye.
Is there any opposed? Seeing none, motion carries. Okay, thank you very much. We're gonna move on to the next agenda item. Is Ross here? Anybody from DOT here? There you go. M1, Ross.
I'm sorry, it's good afternoon now.
Good afternoon.
Good afternoon, board members. Ross Smith from the Department of Transportation Airports Division on item M1. We're asking for approval to amend an existing agreement we have with our food and beverage concessionaire at Lihue Airport. We'd like to add some space so they can put in a new grease interceptor.
Okay, any further questions for DOT staff?
Grease
Any-
interception is really important.
Yes, definitely.
Any members of the public wishing to testify on agenda item M1? Seeing none, board members?
Move to approve.
Second.
Moved and seconded, all those in favor say aye.
Aye.
No one opposes, motion carries. Thank you, Ross, for
Thank you,
waiting.
board members.
Next agenda item is D8. Where's Russell?
D8
D8.
or D9? D9, can we call him D9 first?
You want to do D9 first?
Yeah, only because we have several people here that have been waiting on.
All right. D9 then.
D9 is the request we have here related to the HART matter. HART is the rail line that, and this particular stop is at the stadium. I had some amendments I wanted to pass out to the board, and this came about for further clarification with our meeting with the Stadium Authority just this week. And basically, it's a cleanup matter. The Stadium Authority is actually the EO holder, so it was our staff's mistake. And it's their land. This is where the stadium and the parking lot, and what it is the HART rail line was run through the parking area, as well as stop and they're going to share a joint, they have an MOU going on a joint use parking area. Right now it's characterized, and if I can't do it today, I was probably going to have to come back, but it's the way it was characterized in the title as a perpetual and non-exclusive easement. And typically we give easements for the rail line, that's correct, but the parking area really should be not necessarily perpetual. And it can be an easement or it can be a lease, but it really shouldn't be perpetual because you're kind of designating a land use forever. And I don't know if that's really what was intended here or needed. Actually, I think if they get a 65-year term, that's probably sufficient for HART purposes, at least at this time. But again, right now, we're bringing to the board because of the urgency, I guess, from the HART perspective, is they needed at the very least, the right of entry to start construction on the various areas. The stadium is one of them. Later on this morning or this afternoon, we'll be hearing on the other item, which is in Kapolei, which is our lands, yeah. The changes basically that we're proposing to the submittal is on the compensation and basically asking for fair compensation to be negotiated between the stadium and HART at some future point, whether in the form of monetary compensation or improvements. Okay, and this is at the request of the stadium. Similar, from what I understand of the Stadium Authority, they're very similar to us, where we have in part, like when I've brought before the board in the past for land division, is we have an income component where we try to generate revenue to help support our department. I think in their perspective, they try to generate revenue when they can to help support the operations and repair and maintenance of the stadium, which is quite a big task. But representatives have been from HART as well as the stadium have been here. I understand that even the chairperson was here or maybe here from the Stadium Authority. They may want to speak. The executive director is here.
Before we hear from them, though, you're suggesting changes to the recommendation.
Yeah, and you guys passed it on?
It's inside your folder.
Yeah.
It's inside your testimony folder right here.
again, to point out that currently the area is under executive order to the stadium authority. So basically, that's under their management control, and we're basically consenting to something.
So these are all hard people here?
Stadium authority, Brennan Morioka, I think is from Hart.
Oh, who's the guy in the back there?
Hart, he's with Hart. Okay, so basically the amendment that you're talking about is that for compensation, and the compensation is to be determined via the memorandum of understanding.
Yeah, and
in
it
some
still needs
future.
to, I believe they're still gonna be negotiated
Okay.
in that
All right.
respect. And we want to make clear that the revenue would be going to the Stadium Authority Special Fund.
Oh,
It is under
yes.
EO
Right.
for that,
So
and
it
they're
can't go to
maintaining
us.
the facility and caring for it. We're not managing it. We hold the fee, but that's about it.
Any questions for staff on the proposed amendment? Okay, seeing none.
Thanks. No, I see.
Shall we start with Hart first? You guys okay with?
Morning, Chair, members. Brennan Morioka, I'm the Deputy Executive Director for HART. Well, first, I do want to start off by thanking your staff for all of its efforts in working with us, as well as the Aloha Stadium and the DAGS' staff for working with us through this whole process. We've had a lot of discussion in trying to get to agreeable terms going forward, not just with the right of entry and the lease terms, but also just our memorandum of understanding, which sets the guidelines and parameters for our operational agreements for the station area and the park and ride. For the most part, the amendments are acceptable to us. The only issue that we would have concerns with about is the monetary compensation. We are definitely agreeable, and I think the MOU kind of sets forth the parameters for the negotiations in determining what physical improvements will be a part of the station area and improvements to the parking lot, which HART will operate on non-event days. The stadium will have full control during event days, which would be football games, Great Aloha Run, that kind of stuff. But just the issue of kind of leaving the monetary end open-ended well into the future doesn't provide us with some level of assurance of our ability to plan in terms of budgeting going into the future. Right now, we do not have budget for any future lease rent payments. If there was to be some form of monetary requirement in the future, that would basically require us to raise fare gates, and that just tends to deter people from actually using the rail transit, which is kind of in opposition to what I think we all want in terms of having a station at the Aloha Stadium, which only enhances the accessibility to stadium events. So that is our only concern. Other than that, we're definitely planning on making whatever improvements that the stadium is looking for in terms of how we evaluate the immediate area, and also accessibility from the park and ride and the station onto the other side of Salt Lake Boulevard so that people can get across safely. So, and we'll work that out with both DAGS and Aloha Stadium staff.
Any questions for Brendan?
Oh, sure. You're saying that, yeah, if I hear you clearly, if there was a fee assessed to you, it would be prohibited or wouldn't be in an economic situation because fares would go up. And what you're saying basically is you wouldn't want to use that free where there would be no fees charged to the state, from the state.
Correct, and that's been our typical relationship with the various state agencies, in that we have use and occupancy or lease agreements with the various other agencies that we will use, that we have access to their lands for our guideway or our stations, with the understanding that having our stations there actually improves flexibility for land use options in the future, that enhances its own value, and possible commercial or revenue generation for those agencies who own lands in those areas. Specifically for the stadium, it is meant to improve accessibility and I guess desirability for getting to and from the stadium, as providing a different option, especially on some of the event days that are extremely well attended, where parking does become an issue. So I think that just the acknowledgement that the rail transit system would enhance accessibility, therefore the value of having a rail station at the Loa Stadium provides some level of value that I think somewhat compensates for our presence within some of the land areas.
Okay.
Thank you.
Any other questions for Brandon? Thank you, Brandon.
Thank you.
Anyone else from Hart? Aloha Stadium Authority, Executive Director?
Good afternoon, Chair Ayla, board members. Thank you for allowing us to share a point of view with you as well. My name is Scott Chan. I am the manager at Loa Stadium. We've been working for several years now with Hart, and we look forward to the partnership of moving forward. We feel that it's a good opportunity for all of us to have something in place and to create, a major destination in Hawaii, as Loa Stadium should be. But since we last had our conversations with the MOU, there's been other issues that have come up that warrant that we consider some adjustments to the MOU as we move forward. And all we're asking for is just to make sure that we do not close the door on the flexibility of asking for fair compensation in terms of what's being considered here. We also need to consider monetary value because of the utilities, and also with it being stated in the MOU as well, for the cost that we incur with having this as part of our property. So it's one of several options that we're looking at, not only just the physical improvements to our facility, but we, at this point, as I represent the authority, we do not want to shut the door on the flexibility of looking at opportunities to seek fair value or fair compensation for the arrangements that we have forthcoming.
Okay. Further questions for Scott?
But you see it enhancing the value of the stadium in general and all the types of activities you have, giving people another option to get there?
Sure, but that also brings an impact that we're not aware of yet until we go ahead and work together, as it states in the MOU, to conduct a study prior to and after the rail is put into place, to give us a better idea. So we all have an opportunity to share our thoughts and our findings to make sure that we make the best possible decision as we move forward.
Any additional questions?
Well, I would think that because the recommendation of staff to us now indicates clearly that it's monetary and/or improvements to be negotiated, that there's a lot of opportunity for that kind of discussion.
I think we are closer to getting some of the major projects that we're working on, or the items that we are working on that present other opportunities. I don't think we want to just completely turn over the easement without considering those issues.
Okay. Thank you very much. Is there any members of the public wishing to testify? Wait, we have Chris Klimak of DAGS.
Thank you, Chair. We don't have any testimony to provide, we're just here for technical support.
Okay, thank you, Chris. Is there anyone in the audience wishing to testify on agenda item D9?
Yes. Aloha, my name is Ponoke Aloha, as you know, we're in Milo. I challenge your executive order. Again, Hawaii had no treaty of annexation. You guys are operating on a fake state. And your whole thing with this Hart is going to prime ag land for our future generations. And what it's doing is now urbanizing this area where it can never be used again. My future generations have nothing to look forward to. You're outpricing them. Well, they'll never be able to ever live here comfortably. I'm
just asking to you, you guys really got to think of our future, not yours, yeah? Mahalo.
Okay, thank you. Anyone else wishing to testify on this agenda item? Seeing none, board members?
Move to approve.
We have a motion to approve. Do we have a second?
Second.
We moved and seconded to approve. All those in favor say aye.
Aye.
Anyone opposes? Seeing none, motion carries. You wanna do D8 now?
Okay, D8 is the next hard item, and actually the one in Kapolei, and that is the lands that are under DLNR. Just to give some example, these are the lots directly, one parcel or two parcels is actually directly across the currently built UH West Oahu, and a couple more is up on the Mauka side of UH West Oahu. Since the board submittal was prepared, we had to get it on the agenda, so it was prepared in advance. Subsequent to that, we received a letter, and I think it should be in your packet, from Mr. George Atta of Department of Planning and Permitting, committing, rather than in lieu of monetary compensation, that they will zone the property or via their TOD process, and try to get it zoned for our purposes, which is for income production. And so the board submittal does provide, I think on page 9, the alternative consideration, and that's where we're actually going with. I would just add, and perhaps for the board to consider, is, from what I understand, even if they go through the TOD process, it would require council vote, and so, to the extent that the county is not successful in getting the zoning that they're going to try and get, then we get the opportunity to get monetary compensation instead. Because it is right on the rail line. It is right across UH West Oahu. It is next to DR Horton, and it is very prime income-producing lands for the department, which we use to help support our department operations.
Any questions for Russell?
Really
Thank
hard
you, Russell.
again.
Brilliant.
Aloha, Chair.
Wow.
Again, thank you for your staff in working with us on this, especially Gavin. He's been extremely helpful in helping us understand many of your positions. Very similarly, our position is the same on this one as it was for the Aloha Stadium, in terms of having to pay for the use of lands, especially public lands, was not in our original budget. It's not in our current budget, and nor is it in our future budget. So, having to pay certain fees for the use of the lands, both in the immediate future as well as over a long period of time, if that's what would be required, would require us to relook at our budget, which would include increasing fares. I will say, though, that both we at HART, and I'll speak directly for HART, but also for the city administration, its support of developing the areas around our stations, which includes the DLNR parcels at question, because it is in our interest in terms of rail ridership to have the appropriate types of developments that encourage walkable, rideable, transit type use of living styles. And I think having the DLNR parcels developed in appropriate manner that suits a rail transit type facility is to our benefit, and so you will definitely have our support in that process. I know you also have, and I believe the Department of Planning and Permitting's director had issued a letter reflecting his support and intentions on this matter, as well as they proceed through the TOD zoning process. So that, again, that is our only concern. To us, it's not an obstacle, but I just want to point out our position and some of the potential impact that it would have on us. Thank you.
Any questions for Bernie?
I do. So did HART issue a similar letter saying you use your best efforts to try to get it rezoned appropriately?
Well, through our discussions with DLNR on this whole matter, we have expressed our support. We do not control the zoning process, and so I think the stronger position is coming directly from the Department of Planning and Permitting, which has that control over zoning. Ultimately, like Mr. Suji said, the city council will have the final authority on approving the recommendations made by DPP, but DPP in its letter has confirmed its commitment to include the DLNR parcels in its process.
Seeing no further questions, thank you, Brendan.
Thank you.
Anyone else wishing to testify on agenda item D8? Okay, board members?
So Russell, you guys moving ahead with a rezoning request?
That, I think, my understanding is that the DPP is gonna take that on.
They're gonna initiate it?
Yes.
They usually expedite it.
That would help, I
Agency,
think.
City agency would.
Yes.
As part of the revision of the general plan, that's the process.
In my view, I think what they're proposing, if we were successful, is quite valuable, because it is a tough area to get zoned right now. Kapolei.
Right, but boy, what it's a valuable piece of land.
Yes,
Yeah.
absolutely. Yeah, we
Yes,
need the zoning though, that's the thing. Yeah.
So Russell, if you got the zoning, the proper zoning,
I think we still would have to go land use.
Right.
I strike that, I think it's actually urban, my mistake, I think it's urban.
but down the road, if the rail is profitable and it's making money, would any type of money, because it's such profitable land and it's important land, would any money would come back to the,
All of it, because,
would come to the state?
Yes.
Yeah.
because it's our land that belongs to the land division. All revenue derived from that would go into the land.
This one is
special
not
use.
seeded, so in fact, if it was seeded, we go 20% OHA.
Right.
And if it's income land that we support our programs with, it'll come back to us in our land fund. Yeah. So it'll help, and we've been trying to support our other divisions with funding over the years.
The land leases go to provide funding for firefighting, fires that come up unexpectedly.
Invasive species,
species.
endangered species.
State parks.
State parks when need, yeah. So,
This goes on.
Short studies.
short studies. Possibly molasses studies, we don't know yet.
I'm going home after this.
All right.
Motion to approve.
Second.
Can we, as amended, and I'll make it clear that we're picking the alternative for the zoning
Yes.
and then put in the monetary.
The motion is as
and
amended.
As amended.
Yeah, okay.
Okay, second is as amended.
Second.
Okay. All those in favor say aye.
Aye.
None opposes, motion carries. Thank you. Stay right there. We go to D3.
P3, I think that,
Okay. Rob needs to recuse
is that
himself.
D3, the
Delta
consent?
3, yep.
Consent? We'll sign.
So I believe I need to recuse from this one.
Okay, so we have two board members recusing themselves, Rob and,
Okay, this is a consent to assign general lease from Olson, Edmund Olson, to the trust. I don't have anything to add to this one. I think it's rather straightforward. Did someone sign up on this, the Olson Trust matter?
we have Mr. Olson here. Did you want to add anything? Mr. Olson, did you want to add anything?
Not at all.
All right. Okay. Okay, is there any members of the public wishing to testify on agenda item D3? Okay.
Move to approve.
Second.
It's been moved and seconded to approve. All those in favor say aye.
Aye.
No one opposes. Motion carries. Thank you very much for waiting around.
Thank you.
Number three.
D4?
Four. Glenn, let's see.
Glenn Honda.
Yeah, D4, Fire Department.
Do you want me to get the other guy? With the board member?
Oh, yes, let's go get them back. I don't think they need to recuse themselves on this one.
Glenn Honda still there? Oh, you're still here, okay.
Thanks, Sam.
Yeah, this is just the approval in concept to withdraw 2 acres from an existing lease to set aside, from there we would set it aside to the county for the fire department. I believe the lessee is
I'm sorry, what are we on?
D4. My understanding is the lessee is okay with this withdrawal.
To the fire department, right?
And are you okay with the staff recommendation?
I don't have anything to add to this particular submittal.
Okay. Anyone wishing to testify on agenda item D4?
Move to approve?
Second.
Moved and seconded. All those in favor say aye. Aye. None opposed? Seeing none, motion carries. Thank you for.
Thank you very much. Just to add, I just noticed that there will be, we're going to be, the lessee would be maybe entitled to some form of compensation, and that is a requirement of the withdrawal.
That was in the submittal.
Yeah.
Thank you. Is Samara, we'll go to agenda item K1.
Thank you.
Aloha.
Chairman, board members, Sam Lemo, Office of Conservation. This is, I have one item today. Involves the Kalaheo Water System Improvements, County of Kauai, Department of Water. And a lot of elements to this case, some of which occur in the conservation area and some which occur outside the conservation area. There is a map in here that kind of shows you which facilities are being developed in the conservation area, and it's Exhibit B. So anything with the color is in the conservation area. So we have the Clearwell, major new site development at the Clearwell site. We have Yamada Well and Reservoir, partially in the conservation, partially out the conservation. And the rest of the stuff, for the most part, is outside the conservation district. So those are the elements of the Kalaheo water system improvements that'll be occurring within conservation areas. We've taken it through the normal process of all applications. There's been an EA published, accepted, sent it out to agencies for comments, and we're going to recommend standard conditions as usual, and no major objections to this proposal. And so we're here before you today to have your approval and imposition of the standard conditions.
Any questions?
No, this is long overdue. I know that the Kalaheo community's water infrastructure on Kauai is in need of updating, so
Great.
thanks.
Great. Any members of the public wishing to testify on agenda item K1?
Yes.
Okay, come.
Oh, you're going, sorry. Aloha, my name is Punake Aloha. Again, there's no treaty of annexation. Everything that you're doing is a continue of genocide against our sovereign nation. Now, the VI is our resources. The Aina, this archipelago is our resources. By you controlling it and cutting us off from sustaining a life is heaven. And again, I bring to you, is this Pono. There was never a ceded land. There's no treaty of annexation. Until you guys can figure that out, look it up. There's none. The Ku'e petition, look at that up. Our Iwi Kapuna fought and kept us a sovereign nation. And you guys are continuing an act of war. I plead on you, come on. These are our resources. By you guys cutting these streams and capping them, these are the veins of our Aina, of our Ahu Pua'a.
This motion is simply to provide the Kauai
Well,
board
yeah,
water, the ability
but
to provide
in other
water
words, water is our life.
Right, but provide water for people to drink in their homes.
But by you guys capping it and controlling it, that doesn't keep us alive. Mahalo. Aloha.
All right, thank you, Pono. Anyone else wishing to testify on this agenda item K1?
Motion to approve.
Second.
Been moved and seconded to approve. All those in favor say aye. Aye. Anyone opposes, motion carries. Thank you very much. D1, Russell?
On D1, we're bringing back to the board and asking the board to deny a prior request for contested case by Mr. Kui Palama. The underlying matter was brought before the board several months ago, where the board voted to close down a particular area of state land that had been, at that time, being occupied by Kui Palama and others. Apparently he didn't make a request for contested case at the meeting, but he did later try to submit something in writing, and that's what we had our attorney generals evaluate, and I believe you folks have it under seal, their opinion. And so our request today is to deny the request for contested case. I understand Mr. Kui Palama actually is present here, would want to testify. I just wanted to advise the board, since the time that we closed the area and put up signs and taken back the area, I understand Mr. Palama, from what I understand, has reoccupied the site. And so that's an issue, and I would ask Mr. Palama's cooperation in please vacating that area.
Any questions for Russell? Okay, we don't have anybody specifically signed up, but it's Kui here. Would you like to come up and, you understand the motion before the recommendation before the board is to deny the request for a contested case, right?
Right. Hi, my name is Kui Palama. I'm a living person, and I'm here represented by Postal Service Judge Kelene Kahau.
You want her to come and
Yes.
join you at the?
Yes.
Okay. Could you introduce yourself for the record?
Aloha. I'm Federal Postal Judge Kelene Kahau. I did submit some paperwork to William Milo. I do have a couple more. If you do need.
I'm circulating it right now. The issue before us is whether or not to grant the contested case, but
I understand. But I want to, before I go on, this is not about a sovereignty issue. I just want to make that clear, okay? And how I identify sovereignty is when Barack Obama became president, he addressed people as Americans. We're all Americans in this room. That is a sovereign, okay? But I want to let you folks know this is not a sovereignty issue. Right here in the front, your front paper shows who I am as an authority figure. It's not what I believe, it is a fact. It is a correct sentence structure. So it gives me, I don't create laws, I use them as it was created back in 1775, going back to Philadelphia, excuse me. So it goes back to Title Code 28636. It gives me the authority to open federal postal court. I am an authority figure, that's what I do. So I'm just trying to explain myself who I am as a person and who I am. And if you go to your third page, that's where my authority lies, right here. Wherever there is a postal treaty, I am an authority figure. I can help anyone on the planet and in the archipelago. You have my oath, it's here. Judge Molloway, she has it. You have my claim of life. I am a true living person. And there's an explanation. Judge Molloway has it. It's a quantum interface. It was sent to your John Roberts, Barack Obama, and there's a living pool. This is just to show who I am. This separates me from any sovereign group here in the archipelago. Your next thing is the CPAS Treaty, which combines into a banking treaty. This gives me an authorization for the archipelago because there was a 70-year bankruptcy in the state of Hawaii. I had cleared that to the authority. Your boss, his boss, the Department of Defense, has the same treaty. I'm just clarifying. So what we're talking about today is, I understand, is to give him clearance. I'm representing him because everything deals with grammar. There's 132 islands that I have done in this treaty that I have claimed. You have it on your paperwork. Okay? All these years that we have done, it's either give the nation back or give the people the freedom to be self-sufficient. That's what I'm here for, is to help our people to be self-sufficient in the right state. Nothing to be ku'e, but to give them the right to be self-sufficient and to be humble. Yeah, the next page is our flag, the rightful flag. We don't go ku'e, we don't stand and do our marches. This is to be humble. This is the way to do it, and to do it together as a nation and as people, because there is fraud out there through grammar. I understand what Pono is talking about, but this is the only way so that we can be self-sufficient in things that are to come to understand. I'm the only one that can give a Lodio claim because I am a plenipotentiary judge, which makes me an ambassador to this nation. This is not something I believe, this is something I know is a fact. And if you look to it in the World Hate Court, they have my claim, they have my oath, they have everything who I am. Now, I also saw inside of here, it says that under your law, he has to abide by traditional cultures and standards. And he's failed to do that. I believe you have pictures and paperwork that he grows a lo'i, he does traditional standards of things, but if you cut his water off, how does his lo'i grow? How does those things happen? So we have to give our people some kind of stability. Now he has a map that shows the water comes through this way and it leads into another way. He's only taking a portion of that. That's self-sustaining. That's traditional culture. We have to do what is not just what is right, but what is correct for our people. Whether they be Kanaka Maoli or Kama'aina. They live here on the island. They know what is the culture. They know what is self-sustaining. It's not just about being ku'e or what was done in the past, but what is to be done right here now. I've done many things with you in the past, with Lucio, but that's in the past. This is for what is to be done now and for our children to come. We understand what the laws need to be done here in the state of Hawaii. But what about all people? They're trying to be self-sufficient. They're trying to raise their family in the right cultural way. And how is that to be done? If we demean them, and you have laws that say they need to do Hawaiian gathering rites and traditional cultural practices, and you come with bulldozers and dirt and stop the water rights when it is part of our right. Is it right or is it correct? Or is it fraudulent conveyance of grammar? Let's think and ponder about this. You know, sometimes we overreact and we get arrested because we take over something that, we have to think and ponder. So now let's look at the grammar. And that's what we're asking. That's what we're here today. To let's do what is correct. Not just in our now and our hearts, but in our grammar and the way we speak to each other. That's why we're here. He's only doing what is right for the people, not just his family, but to teach others how to go in the lo'i plan, pick the huli, make it so that other children can learn, other families can learn. Feed the goats, feed the horses, feed the cattle, so we can be self-sufficient here in the islands, like we used to be. This is where it has to begin. So, I ask you, can we have a compromise? Can we do this for the children and the people of our nation? Even if we're not Kanaka and our Kama'ainas, this is what it's all about.
What are you asking us? What's before us is whether we, put the bearing on the contested case within our rules and our laws, which is what we're able to talk about.
I understand.
So it's out of purview of what you're talking about. So what are you asking us? I'm confused what you're asking us right now.
Okay. So, I'm asking, can you give him leeway of this land? Because if you look on his paperwork, his family, his paperwork is actually part of his family. Yeah. Well, he's occupying this area, right? And you have claimed that you pretty much own this area. Am I correct?
That is correct.
Okay. So
Mr. Palama has made a presentation of basically a land
yes.
Claim.
Yes.
We've researched the land claim via the documents that we have. And our assessment is the land, partial of the land that is being occupied right now is state land. There's a bit of private land in which we built, based on the documents, that the Palama family may have Juliana rights to the private land.
To that private
but
property,
not
yes.
the state land.
Right.
There was a time when we would have entertained, and I made the offer, Mr. Palama wasn't here, forget your name, brother, you was here, and you took the message back, that we would have considered a right of entry, revocable permit, because the board in past actions have agreed that it is good for people to be self-sufficient.
Right.
It is good to honor traditional and customary practices. The challenge for us was when we put that offer on the table, we got back papers that said, we reject your offer, the land is ours.
Okay.
So that's when we spoke earlier, I said, this is, if the paperwork is on the table saying that the land does not belong to the state, the proper venue for deciding land ownership in Hawaii is the land court.
Okay.
The land board does not decide title.
And I understand that.
So, I mean, we made an offer, Mr. Palama and the family, to continue doing what he's doing, but he has to comply with
Right,
state law, right?
exactly.
So, to divert the stream would have required a stream alteration permit.
Right.
So the
I
work was
understand.
done without a stream alteration permit right now,
Right.
which
Okay.
is a violation of
Right.
the water code.
Right.
Okay.
And I understand that.
So, I guess you're asking, could we entertain a way for him to do what he wants to do? The answer would be possibly after the violations are dealt with. We can't give you an opportunity while there are violations that are in progress.
Okay. The violations that he showed me was that there was a dwelling. Is that the violation? And the violation.
There were a number of things.
And
There
the
were some
violation
dwellings, there were
as far as.
The SCAP, the not having the stream alteration permit.
The stream, okay. Now, part of that stream alteration, isn't that part of Kuleana rights?
It could be, but he doesn't have Kuleana rights to the state land. He may have Kuleana rights to the private land. So the water going to the
Okay.
private land is a
And-
possibility.
And now that's where I step in, you see? And that's what I was trying to explain to you, whereas that's where I step in and that's where I'm able to give the Lodio claim. But to
the
his
excuse me, but the allodio claim is not, we cannot adjudicate in the land board the allodio
Okay.
claim. That one has to go to the land court.
Okay.
We don't
So-
have the authority to
Okay,
do that.
all right. So now he's gonna go do that. I'm gonna go play this role again, because I've done it before. So I'm just letting you, it's just a notification. Because it's not a Lodio, it's Lodio claim. So I'm gonna play this role one more time then. That's what you're telling me.
Well, if there is a land claim, or if there's a water claim that's associated with
Mhm.
land, right?
Mhm.
Then the land court is for the land title.
Mhm.
The water commission decides water rights and water access.
Okay, and then that's where the CPAS comes in.
Well,
Yeah,
okay,
because.
I know that you are asserting that that's where it comes in.
Because the military
I-
has this.
I can turn to my attorney general and ask
Yeah.
him,
Well, his attorney general, his boss, David, knows about this. He's been giving this.
but just because we've been giving something
Mm-hmm.
does not make it
Well,
so.
then his boss and the prior bosses up there, they all know it. It's just you guys have this thick veil because it hasn't been come down to you yet.
So until such time.
I'm
that
not
it
trying to
comes- No, no.
demean you,
No,
I'm
I-
just,
I agree with you, but until such time that it comes down, we have to
It's not a problem, because it's my.
continue to behave,
Yeah,
according to
I understand.
the laws and administrative
understand.
rules that we have, right? Until we're told.
Okay. So the procedure is for him to go to the land court and me to walk this walk with them.
With regards to the private piece of property.
Property, yes.
Because we're gonna disagree on the adjacent piece of property, which is,
Right.
according to our title search, state land.
Mhm.
Okay.
Okay.
And currently, I think you have some property that's still on state lands. There's still the issue of dealing with the stream alteration permit
Mhm.
that is not proper. So for us to get to a point where we could issue him an RP or issue you some sort of right to be on our lands,
I
right, the state
believe he
lands.
has an RP already.
Right? We would need it to be cured,
Yeah,
okay, via the state rules and regulations.
okay.
So that's where we're at today. So he's coming before us, asking us to give a contested case hearing. The staff's recommendation based on legal analysis, our legal analysis, our rules and regulations is we can't give him a contested case hearing. So that being the case, if the board takes a vote and we don't, then we're back at the point where we're gonna serve Mr. Palama legal notices, and then we're gonna come back in with the bulldozers again until it's cured. Once it's cured, then we can talk story about.
So you want him to pay for something that is his right to the land?
It's not his right. The state has an obligation to balance traditional and customary practices with public health and safety issues and the running of the state's business. So it's not an absolute right, it's a
So
right
where
that's
is the
determined
public-
on balance.
I want to ask, where is the public health services that he's violating?
He's occupying state lands right now without permission or without authorization.
But I just gave him permission. That's
Okay.
where my authority is stepping over
So
you.
I'm gonna just say for the record that until I'm told otherwise by the president or the governor, I cannot recognize your authority at the land board level. So therefore, he's still in violation of state law.
You cannot or you will not.
I cannot.
So we'll just go over you at this time.
And that's certainly your right to do so.
Okay.
Okay. And if a higher court or the president issues a lawful order that we can recognize you, then by all means, at some point in the future, we may, right?
So at this time, you will deny him his traditional practices?
No, we're denying him the motion, or the motion. The recommendation from staff is to deny the request for a contested case hearing. That's what's before the board right now.
So you want him to file in the land court for that property?
That's always, well,
That's what you want.
if he believes, okay, there's two pieces of property, let's be clear.
Yeah.
The state
The
claims
one
is its
outside
land.
and
Outside.
the one inside that you...
Not the one where you actually, I think, have some Kuleana rights, which is a privately owned parcel
Yeah,
and
because
you
that's
share.
the one he wants, the Kuleana rights.
Okay, so that one, you gotta go deal with the current landowner. You two guys are joint owners and you guys gotta go work something out.
Okay.
You still need a SCAP, you still need a stream alteration permit to take
Okay.
water from the stream to go to that parcel of land.
Okay.
To grow taro. Okay, but you're a co-owner like the other guys are co-owners, so you have to work that out with them.
Okay.
But on the state property, cannot, and currently, if there's any buildings, structures, equipment left on state, you had to notice, right, so.
But there's no buildings on the state property.
You moved it over, all to the other side.
There's no
Our
buildings. I
last-
never had a building on the state property.
Weren't there the stables and where the dog houses were, that's where the dogs were kept?
The dogs, they moved it.
Okay. Okay, so,
Diversion, I believe, is.
okay, so the diversion now is the last remaining violation. Now, what you can do is you can apply to the Water Commission for an after-the-fact stream alteration permit.
But how on Kanaka like me gonna put a meter in and tell you how much water I'm taking and how much water is going on? I'm not doing it commercially. All the growing taro just for
No, it's
sustain my
just-
kids.
It
I'm not-
doesn't, this is not about how much water is gonna be charged for anything
But I
like
seen
that.
the permit. That's what it says on the
The
permit.
SCAP, the stream alteration permit, merely gives you permission to alter a stream. Now, there's a water allocation issue that comes after the stream alteration permit. Okay? How much water gets taken out of the stream, that has to be vetted in terms of what is the impact on the rest of the stream, right? I saw the pipe you put in, it's not that much water, okay? But we gotta go through that process. The board cannot say, hey, looks, the pipe is small enough, go ahead. The Water Commission is charged with that responsibility. So there's another board that you have to go to cure the violation. The violation is you didn't ask permission ahead of time to remove water from the stream. And whether it's a Kanaka or whether it's Alexander and Baldwin or whether it's anybody, we would be taking the same action.
But they get their Alexander and Baldwin is more of an issue than mine. Is more of a public matter for safety for the
But
public
they
than
have,
mine.
but they have gone through the process to either get the SCAP or those water diversions were put into place before the law came into effect, so they're grandfathered.
So they're grandfathered. So I get royal patent title to the place. So what would that make us if Alexander and
So
Baldwin?
your claim would be, if you have a royal patent,
Right.
right, your claim would be, I have a pertinent rights. That's your claim that you would put before the Water Commission.
I already did send them something.
To the Water Commission?
Yes.
Okay,
I
so,
forgot his name. I have it in my phone. But
Bill
I
Tam.
did send him something.
Bill Tam.
Bill Tam. And he told me he would review the documents and get back to me. Then I was served by, I believe, Milo.
right, because that's the land side.
Right?
Okay, so we have two.
So they never got back to me, the Water Commission. After I give them a nice notice, emailed him, he emailed me back. Thank you, I'll review the documents. Never got back to me.
Okay, okay, so all of your personal property is off the state property, right?
Most of it.
We'll have to go,
yeah.
most of it, so
Yeah.
move the rest off. That cures the land violation. Now, what we do is we move forward to the Water Commission and make an attempt to cure the stream alteration permit.
But I get one you know, the property, they came there, they surveyed it. It goes across the road. You know when you drove up there?
Yeah.
See that? You're driving up on the road right in front of our fence. Our property goes right across the road. But I left the road open, knowingly that everybody who goes up there, they gotta go up, they gotta get on access. Just like how we supposed to be able to access our Kuleana. Everybody access right through our property, goes across the river, whatever they do, water department.
There's likely an easement on the private property that you have for the road. So it would be in your best interest to keep that open because
That's why I
there's
did.
likely an easement, that a legal requirement for you to keep it open.
But it's not a county road, so how is that an easement? So I figure instead of blocking off the road so I can make more lois, so I can feed more people as well as my family, now I gotta suffer and grow lois only because they're taking 100 feet of road.
We encourage other folks to grow taro. We would work with you to grow taro, but you have to take care of the violations first. Once you take care of violations, then we can work with you, whether it be on the private land or if you want to do a revocable permit on the adjacent state land, but you gotta cure the violations first.
Because I feel like Milo, I don't think he's here,
Milo's
the
not
land
here.
agent,
Yeah.
he has a personal grudge against me because my uncle went into his office, applied for a permit, he put it on hold. He was gonna give my uncle a permit. So what was the difference of my uncle getting a permit
Because
to
you had
lease the land?
violations. Because you had existing violations at the time, we cannot give a permit to someone who has existing violations.
But he told me if I sign the permit, he wipes everything off. How is that?
You gotta comply first, and that's what he would have told you. If you complied first, then we could certainly consider you for a revocable permit or some other leasing situation. Okay? So we're offering an ability to become compliant,
Okay.
okay? So the next step is, if you've moved everything, and you haven't, because you just said mostly everything, move everything off the state land, now you're compliant with the state land, the occupation of state land. Now we still have to deal with the unauthorized diversion of water. That goes to the Water Commission, that we work with Blnr to fix. You can apply for an after-the-fact permit, not saying it's guaranteed that it's gonna be approved, but the process is you certainly can apply, and then we'll see what the impacts are. We're not saying no, we're just saying we have to do some things first.
Then it has to be approved because that's part of his water rights.
He has a stronger case if he has Juliana rights to a
Yes, he
parcel
does.
of land, because pertinent rights,
Yes, I know what a pertinent
okay,
is.
so pertinent rights have a higher degree of
I understand.
priority.
Yes, I do.
But he has to tell us, he has to make the application,
Okay.
and he has to cure the violation.
Understood.
Okay.
Understood. And I believe he has told you that he has Kudama property.
Okay, so you put in an application, I will go and check.
Application at,
Water Commission is what you told me.
I didn't put in an application,
Okay.
but I sent him facts of why I have a right, and he said, okay, good, he's gonna review it, and he never got back to me.
Okay, so I will speak to Mr. Tam, and we will begin a process, or tell you how to begin the process to request an after-the-fact stream alteration permit.
I'm not trying to play a
That's-
hard ball, I'm just trying to grow food to feed my family, be self-sustainable.
Okay, and we honor that, that's great.
That's all I'm trying to do.
And we honor that, we just have to do it where it meets the law. Okay?
You know, this part, it said, Article 12,
Section 7.
do you have that on you?
I do not have the state constitution with me.
Okay.
But again, it's not an absolute right. It's a right that has to be balanced with other rights. The right for the state to protect public health and safety.
I understand.
So, yes, and he actually has a real right, if he is
Kuleana.
truly a Kuleana landowner, a part landowner in that, on a pertinent rights, on the ability to grow taro.
Understood.
Okay, but we gotta resolve that
So, but shutting off my water is not resolving that.
That's one way to solve the problem. The other way is you apply for an after-the-fact stream alteration permit with the Commission on Water Resource Management.
Okay, so if I apply, and then they take, I don't know how long it's gonna take to come back, to get back to me. So you send a backhoe up there and bury my ditch
We
again?
may or we may not, but how that's gonna start the process is
That's,
get the
that's
application.
kind of like all part of the genocide effect, though.
No, no, no. Okay, so what we're trying to do is we're trying to bring it into compliance. We recognize that he has an
Understood.
pertinent right.
Understood.
But you gotta go through the process.
But turning off blocking the water, that doesn't really help the situation.
Blocking the water or
The-
taking out the diversion
Yeah.
is the legal remedy.
By
Right.
cutting off the water.
It's the legal remedy.
So you would say,
Because
I'm gonna
there's-
shut your water off
because
unless
there's-
you do this.
Well, if he applies, right now he hasn't applied. You made contact. If he applies, then one of the measures, the interim measures might be okay. You have temporary permission to run the water through the pipe until we make the assessment and make the determination, okay? That doesn't mean we won't come up there and shut him off tomorrow, but at some point, you have to put some piece of paper before us that says, I want to remedy this situation by doing something.
But just of the fact of you recognizing that is a Kuleana land, that if you recognize me as a
Yes, but you still have to
Kuleana-
go through the process to get the stream alteration permit.
as a Kuleana landowner.
That's correct.
But
Any
that-
other
that's
Kuleana
not in the
landowner.
Kuleana land rights, that it's our right to take
It's a
out.
right to get water. It's not a right to take water without permission.
Where are we taking it though? I putting it back.
You're taking water from the stream.
But they're putting them back right in
You're
the
taking
stream.
water from the stream with a stream diversion that is not approved. So we can argue philosophically, but that's not gonna get you.
I'm not trying to argue. I just-
You're asking me a rhetorical question. I'm trying to give you a procedural answer. The procedural answer is, if you want to work towards making this happen, then I'll talk to Bill Tam, we'll get with you, you put the application in, that's the first step, okay?
Okay.
Then we decide, the Water Commission decides whether or not you keep the pipe going or we take the pipe out until you get the permission to do it right. That's the next step. But you gotta get the application in first. If you're gonna ask me the rhetorical question about philosophical, do I have the right to water? Yes, you do. But do you have the right to divert water from a stream? No, you don't without permission. Okay, so it can happen. I'm telling you that we can make it happen, but you gotta do some things.
Because of the law. So-
Because of the law,
Because of the law that you folks follow.
yes. Because of the law that we have to follow. Okay?
That law.
Chair,
Forgive me,
I-
Arnie.
Yes.
Is there a staff person that they can work with in order to initiate paperwork?
Well, I will, since he made the inquiry with Bill Tam, I will ask Bill Tam to follow up. So, the first deputy for the Water Commission will follow up.
As soon as they send me a notice, I responded back to him.
Okay, so the next step is send you an application. All right? But I think also on the land side, you still have some equipment and/or buildings or building materials that's on state land. You gotta cure that too. Okay?
Okay, so, one more thing. You gotta give him at least 10 days, 10 to 30 days. That's like our rescission act, yeah. None of this 5-day stuff. Because that gives him time to respond. So we give you the same time, yeah. So,
It's been about 3 months since the
I understood
notification.
that, but he's been responding,
On the
he's-
Water Commission side.
Yeah, he's
But
been
not the
responding.
land side.
Both sides have been
Both-
responding.
He's been
Okay,
responding.
but you responded with a title claim. You said, I own the land.
I didn't say I owned it. I never
That's
said I
the,
owned it.
that's the pala that I got from you, saying that based on my genealogy, based upon my genealogy to this person who was given the ahupua of da-da-da, I can be on that land. And that's why I said, The board does not adjudicate land titles. The land court adjudicates
Right.
land titles. So we're not the venue to make that.
Right.
That's why we offered you. Cure everything, then make the application. If you wanted to use some state land, we cannot do nothing with you until you cure all the violations.
Violations, understood.
You cure all of the violations, now we can talk.
Okay.
Okay?
So how fast you think that'll happen?
There's two things that has to happen.
Yeah.
We're gonna go back and we're gonna verify whether or not in a short period of time you remove the rest of your property from state land.
Okay.
Okay. If you don't do so, then we're gonna come in with the bulldozers and we're gonna remove that off the state land.
Okay.
Okay.
Like what, the taro patch is considered a property?
Yeah,
One taro patch?
yeah. It's
Can,
considered your
could possibly
personal.
feed your workers when they
It's
come up
considered
there
your
and-
personal property. You put it there without permission on state land. Okay?
What
You
if
don't
it
have a
was
lease.
What if it was already there? All they did was cut the grass and boom, there was Lois restored. I get pictures that the whole
You
valley
didn't
was
have
Lois.
permission to go on state land and do anything. So that's a violation. Okay?
You guys would actually hurt the lo'i that could feed people.
In order to cure it, okay? And the best thing you can do right now is.
Just say yes or no.
No, the best thing that you can do right now is go and harvest all your taro that's on the state land. Okay? That's the best thing. That's how you cure. Harvest all of the taro, stop farming there. Go to the privately owned land that you have a claim to. Now you're cured. Now you can come back to us and say, hey, I'm cured. Can we talk about a revocable permit? Can we talk about a lease? But we can't do that
But
until
who should I
you
see
cure.
to do that?
You're gonna have to deal with Milo.
Because he seems to have something against me. Because he don't answer, he don't return my phone calls, nothing.
Because you're in violation.
But how are we going to fix him if the land agent on Kauai,
I'm sure he told you exactly what I told you on how to cure it. Okay? And you obviously haven't responded because you still have things on state land. So the first step is cure it. Then the land agent can
And who's
begin
the land
discussions.
agent on
Milo. Okay? So you gotta cure it first, because as long as you don't cure it, then we have the notice of violation that's standing out there and a notice of eviction that's standing out there.
because I read his testimony that he said that.
Don't get hung up on that, brother.
No,
I'm giving
but-
you a way out.
No, I know that, but
Sure, no.
I like
You can
just,
come up and talk
I like
afterwards.
just know what is my threat to the public safety?
Your threat is you are using land without permission, just as we would do the same thing to anybody else.
So what if I told you using land without permission? Because I have a
You're-
treaty
you're-
here.
You're able to say that, but I'm not able to recognize that. So what we need to do is move on, right? So either we're gonna come in and clear everything off, right? Or you gonna do them. Up to you. Okay? Then, if you wanna work forward in a legal manner to do what you need to do, which we agree should be done, land made available to people that wanna grow food, hey, we there with you. But the process has to be pono first. It has to be right according to the laws that I have to recognize. And right now, until the president tells me otherwise, I cannot recognize that. He said
These
they're fine.
laws is what those laws actually are based on. This is Congress laws.
It's not. Okay?
Well, it is. If you do your research,
It's-
Congress is based on these
It's-
laws.
okay. So
It's only
we-
written in
We're gonna have this
syntax.
philosophical difference, but I'm gonna tell you right now, in terms of what the attorney over there is gonna tell me I can do and cannot do, I cannot recognize that right now. When the president tells the chief justice or the attorney general for the United States to
Well-
tell the other attorney generals.
Eric
then-
Holder knows these laws. He's the one that
Okay, so he
takes my
hasn't,
paperwork.
he hasn't told us to recognize that yet. So you might want to send him a letter. Okay? He hasn't told us, so I can't.
Chair, I appreciate your leeway and patience in this conversation, but at this point, I'd like to request that we
Go back to
keep
the
the
agenda.
conversation back to what the matter is on the agenda for our sons.
So out of respect for the board, can you speak to the,
I understand. Sure.
okay, so there was somebody else that wanted to testify.
I just had one question on,
Identify yourself first.
my name is Connie Pilkington. lived on Kauai all my life. Good friend of the Palama family, the whole family as a whole, which never claimed, especially him, to own the land. They never claimed they owned the land. They claimed rights to the land. But my question is, how is he supposed to try to make everybody happy and go forward with Milo, a new guy dealing or new to the island of Kauai? Kauai is a very tight-knit. Sean knows that. You was on Kauai, boy, all your life, right? Correct?
Correct.
It's a very tight island.
Ask the question.
No, my question is, how are we supposed to work with Milo when he's a very confrontational man? Like he says, he might have a grudge, chip on his shoulder, or whatever. He brings in bulldozers, he brings in Buddy Wilson. No, and he's yelling at people and he's trying to make fights. How are you supposed to work with somebody like that? Because he has this status, I am the state of Hawaii, this and that. Because he has a personal issue, he's not going to let anything go forward.
Number one, regardless if it's Milo or anybody there, cure. Okay, you got the pala, you guys got the pepa, you got the notice. Cure, number one. Until you do that, we cannot move forward.
But I did meet with Milo.
Okay. We're not going to rehash this, right? You either cure or you don't.
Okay, so in curing, you're talking about
moving all of
the stuff. So how about the lois? We have to bulldoze it and grade it and compact it or something? Or can we just remove the collar out?
Take out the collar right now.
And then, I mean, are they going to come in and bulldoze and make, because he has a chip?
I don't know what we're going to do.
What do you mean you don't know? That's kind of a big trip, you know what I mean? This guy is very confrontational.
Look, let's talk about the other side, okay? He was also threatened, okay?
By who?
By your family.
Not by me.
By your family, okay? So, when we send guys out there, hang on. The choice right now, we can talk about, everything what you like. The choice right now is we're going to decide whether or not to give you a contested case hearing or not, okay? The next step is we're going to come out there, and if it's not complied with, we're going to take action, the appropriate action, okay? Which means you can remove the taro or we can remove the taro. It's up to you. The taro is part of the property that's on there that doesn't belong there, that's not authorized to be on state property. So that's up to you, okay?
I didn't know.
Once it's cured, now we can talk story. So we cannot talk story until it's cured.
Can I ask if you guys would help us out with controlling some of your agents that are very aggressive and confrontational?
I'm going to answer that question this way.
We got rights too.
I'm going to answer the question this way, and I'm going to talk after this. We're going to end this. Cure first, then we can talk. Okay? Real simple. Cure first, then we can talk. Okay, so anyone else want to testify? Okay, that's the procedure by which to have future discussions.
Yeah, hello.
Hello.
My name is Steve Cowie. I'm with Helena Kahau. I'm a clerk of our court. I'm here to...
Sorry, which court?
Of Helena Stock, the Federal Postal Service Bonds. And I'm the clerk for that court, one of the clerks. And part of my duty is to go and review the things that come into addressed towards us and then QC it and pass it on to her. Now, I'm not the clerk on this particular case, but I'm just here to share, as we say, the due process. So part of it is, have we touched all parties involved with this case? We're here also just to touch all the parties that are involved with our
case. The case before us right now is whether or not to issue a contested case hearing or deny a contested case hearing.
Right.
So we've heard all about what people believe.
No, this is not what I believe. No. That's why we brought those documents to you.
So I'm gonna exercise my jurisdiction as the chair and say, unless you have additional information regarding the contested case, I'm gonna ask you to stop testifying.
Well, I'm not testifying, rightfully. I'm just telling you, as a clerk of the court, and it's our responsibility, we want to know all parties involved. You've been given that piece of document to let you know you've been served.
Okay.
Okay. So that's the reason for
Thank you for the service.
So if there are any more, before we keep going on and we get another party coming involved.
Thank you for the service.
Okay.
Thank you. Anyone else wishing to testify? Okay, come on. And could you keep your testimony to the issue before the board, which is the contested case?
Yes. I'm Koila Palama, who is dead. I just we just know that we have our rights on our Kuleana land over there.
Not the state land.
And I got one question for you, if,
Go ahead.
about the water rights, you know, I get document pictures in the old map that we just following the same manual that comes down to our patch.
Okay, understood that, and we had the discussion, you heard the discussion before. Yes, you have a pertinent rights. No, you do not have the right to divert the stream without a stream alteration
But
permit.
the thing was, it's original diversion before. We get pictures of the streams that came down to the Lodi.
Streams change. The river moves. The river is not that way today. So you moved it back to the way it was 40, 50 years ago. That's still a violation of the stream alteration permit. Okay?
The violation in you guys' laws?
Yes. Okay? But I've explained a way forward. Okay?
So what about with, above that, up by Manawai Puna Falls, all the diversions like that? Is it legal for them to take billions and billions of gallons of water?
Yes, right now, yes.
And down below, you get McBride taking billions and billions gallons of water?
Right now, yes.
They do have the rights, and we just taking.
I cannot go back over
legal
history.
access.
So, yes, they have the rights because, number one, they were taking water prior to the advent of the water code. Okay? You can have the right to take water. Okay? You gotta apply for the stream diversion permit. There's a way forward. Okay? That's what I put on the table before you guys. I made a commitment to have Bill Tam contact you and provide you with an application so that we can begin the discussion going forward. Okay?
So what about the agenda is a contested case hearing?
Okay.
So I mean, what is?
You're obviously, I would think you would oppose the fact that we want to deny you a contested case hearing. A contested case hearing is very similar to a judicial process where you present evidence, we present evidence as to why the board's decision was incorrect when it denied, when it actually responded to staff by saying there's a violation going on, an illegal occupation of state lands, and the motion was to move forward with an eviction. Okay, so the basis for the eviction would have been what you would have appealed for a contested case hearing. Unfortunately, you didn't follow the procedure. The procedure was you give verbal notice. You weren't even here.
I wasn't here.
Right. So unfortunately, the fact that you weren't here, although you were given notification to be here, and then follow up with a written request and the payment of the fee, 10 days went by and you didn't. So on a technical term, we cannot give you a contested case hearing. But better than a contested case hearing, we're giving you a way out. The way is to cure and then come back.
Okay.
Okay? We want people to farm. We've given many RPs and leases for people to reestablish Loi. We want to do that, but you gotta do it according to the rules and regulations that we have. Okay?
We have to establish some control, or it's just gonna go, so the chair is just really trying to fix it. And I'm happy to meet with you, Kui, on Kauai. If you don't wanna talk to Milo, I'm happy to be a liaison for you. So, I the chair is offering you an opportunity to just fix it, and then we can talk. We can't do anything, because if you just gotta think this was happening statewide, there's gotta be a protocol we follow.
Let's just say something. One day it will.
Okay.
I mean, I understand what you guys saying, work it out, yeah. But I'm just saying, one day it will.
Connie has my number, I'm happy to chat with you anytime on Kauai.
Okay. No, sounds good.
Okay.
So the state's policy is to double the amount of food that we grow here in Hawaii in the next 20 years. So we agree with you. Just gotta do it.
Wish you
according
see the shirt that my friend is wearing right there. That's what we're trying to do.
Okay, then
Not
let's
bring in
then-
90% of the
Then
food.
let's work together to reach compliance.
Yeah.
Okay?
Yeah.
Okay, is there anyone else wishing to testify on this matter?
You fellas.
Okay. Who's gonna testify?
We heard from her earlier.
One more thing. So all this file and all this stuff moving forward, and you guys come there, block my access to my kuleana. How is that legal for you guys to stop me from going? Because you just said there's an easement, yeah?
Okay.
Earlier.
So you're a part owner of a piece of land that has
I'm not
kuleana.
owner, it's
Okay.
kuleana is my
Well,
responsibility.
somebody else has bought shares of that kuleana, right? Okay. So if you have kuleana lands and you obviously have the paperwork, then it's the state's responsibility, if there are state lands adjacent to you, to provide you with access, once you're compliant, okay?
Compliant to what? To what we just went over? Taking us structures. But how am I gonna be compliant if they stopping me?
Okay. Let's fix the Water Commission violation. Move the rest of what you have on the state lands off, okay? That's how we get compliant. Then we can talk to you about the rights under the kuleana, access,
Right.
the rights under the kuleana for water, but it's gotta go through that process, okay?
Got it.
All right?
Thank you.
Once again, last time, anyone wishing to testify on this agenda item? Seeing none. Board members, the staff recommendation is to deny the contested case hearing.
Motion to deny.
So we have a motion to deny, we have a second?
Second.
Moved and seconded, all those in favor say aye.
Aye.
No one opposes, motion carries, so it's denied, but now we have a plan to go forward, right?
Thank you guys, that is awesome.
Okay.
Let's take your word for it.